Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Alrighty. Welcome back to the Court of Public Opinion. I'm the Recovery Addict. Happy Tuesday afternoon. We are just getting set to, let's see. Who was first in chat? I need somebody to fess up. Who was first in chat today? I'm not seeing it. Let's see. Well, I was just celebrating. Brandy Churchwell hit 20,000 subscribers. Matthew Harris is at 18,000 subscribers. Just great benchmarks for two great friends. So I wanted to just throw a little party. Yay! We're super excited for both of them. It's Krista. Krista. Welcome. You know what's up. You've won many times before. Congratulations. You have won again. You're first in chat, and we're going to send it to you with internet ownership. That means you are responsible for all the internet problems everyone else is experiencing worldwide. And by responsible, I mean you have to fix them. You can't just be like, oh yeah, sorry, that was me, my bad. No, you've got to actually fix it and make it work and make it right. So in addition to everything else you're doing, just go ahead and add that to your list. Congratulations, Krista. You seem happy about it. Like, sure, bring it. Chat not on screen. Chat on screen now. Thank you very much for that reminder. But Krista, you are a big winner today. Congratulations. All right, we are about to restart court with some amazing closing arguments from a pro se defendant who might also argue sov sit in his closing, which I think the judge will shut down. I don't know if he's going to try to do jury nullification. He's been fairly informed about things before, so it might happen. Chat doesn't work for you anymore. I don't know why. All right. Well, we might have to rebuild it. I will tell you. I got an envelope in the mail today, and it's like, I mean, I'm going to cover my address, but it's just black. It's like a black envelope, and came to my house, and one stamp. I'm like, what is this? Like anthrax? What? Who sends a black letter? I'm like, do I even open this one? And I did. I opened it, and it's an ad. It's an ad. So I opened it, and it had like this $100 sticking in there, but it's not $100. It's fake. It's fake. It looks like that. On the back, it's like some pyramid scheme. This is how I make $3,000 to $5,000 a month without doing anything. You pay me, and then I'll tell you how it goes, and then you can put your name on the list. It's literally it's like illegal. It's illegal. Put that right in the circular file where it belongs. Who sends black envelopes to somebody? It's like, hey, bad news inside. But yeah, sorry, that's not me throwing gang signs. I have a tickle on my nose, and I was just trying to. Yeah, I was not. No gang sign there. It was a death note. I'm like, I literally told my wife I'm going to open this one outside just in case there's anthrax in it, and I did, but there wasn't. So just if that was you, just no, switch to different color envelopes. I know they're probably cheaper because nobody wants them, but black is a no-go. All right. Pretty sure that was a gang sign, says BAP. Grim Faded is like, I'm in. That sounds awesome. Yeah, and it matches your name, Grim Faded. So, well, you noticed, didn't you? Yeah, it accomplished its goal. It got me looking at it. But let's see, we keep getting fake scratch tickets in the mail, and it always tricks the grandparents. I tell you, the one you want to. Here's a little side note. Well, we're waiting for court to come back because this is where we're at. We're still on the lunch menu. It'll come back here in a minute. But while we're waiting for court to come back, the ones you want to do are the ones from the car dealerships that have the scratch off and win things, because they send them to the lowest number of people. It's usually like, between 10 and 50,000 people. So your odds of winning are much higher. By law, they have to have a winner that's sent out. And although the prize is not $10 million usually, it's you can win like an ATV, or you could win a couple $1,000s, and at bare minimum, you get like $2. Everyone's a winner. Those are the ones you want. I always go and do that, but sometimes you have to sit there and talk to the guy and like, look, I have no interest in buying a car, zero. As a matter of fact, if I ever do buy a car, I won't buy it from you because of what you're making me do. But by law, you have to give me my prize. That's me. That's what I do. All right. The rightmost is Ethiopian cuisine on injera bread. Injera. I don't know if it's a J-Y. Yeah. My pronunciation is obviously native. So I don't know how to say it. All right. While we get set, I think we're going to go straight into, they're not, the queue's not even here yet. So obviously we can't start just yet. Black envelope could be over the hill birthday party invite or a wedding invitation. It's a nice day for a black wedding. That's a little take on a different song called White Wedding, if you didn't know. Let's see. Creative B, by the way, I can say this now because most of my mods have got them, but thank you. You did an incredible job. We got some thank yous for our moderators. I still have one that I need to find a way to get to because international shipping is a little bit tricky, but once we get that sorted out, we'll get that one in the way as well. But Debbie at the Creative Bee, she has a shop called the Creative Bee on Etsy, and she sent me one. She sent me the plaque, actually, the one you see over my shoulder right here. She sent that plaque to me when I reached 5,000 subscribers. And I wanted to give a thank you to all of our amazing mods. And so we made them a little something as well to thank them for the great work they do on this channel, because I couldn't do this without them. But hopefully I didn't spoil it to the couple mods who haven't got it yet. I'm sorry. I should have waited. Reminder to check your mail. Yes, check your mail. And she did such a good job. Such a good job. But I highly recommend. I mean, it was custom. It wasn't something that was, and it was easy to work with. She just took care of it. She's really quick, really good quality. Just, I can't say enough good about it. It's an amazing little shop you have there, and you do great work. All right. Oh, no. Woman 406, I am so sorry. Prayers for your sister-in-law. That's hard. I'm so sorry. Let's see. Top Mark mods, check your mail too. We need to get some addresses from them. All right. Check your mail, or checks are in the mail. It's definitely the first, unfortunately, Robert. Okay, let's see. We've got one defendant. We're just waiting for the accused. And then I think we're ready to start. All right. Just notice the defense attorney's pink suit is a soft, flowy material. It's like a silk. Cachette says this community is the best, on the way to 100K. Look at this. 15 months, Cachette. 15 months. Where did the time go? It's crazy that we can say, what were you doing this time last year? And now I can say this, which is just bizarre. It's amazing. I love it. Let's see. Haven't done anything for Top Mark mods yet, Ashley. Not yet. We'll work on that. I've got, let's see. Polyester doesn't flow. I can't tell. I'm not really good with clothing to begin with, but looks like the state's getting all excited and getting ready to, maybe they're verifying the evidence and exhibits right now. So with this being a capital case, by the way, capital case means that it's like death penalty as an option. Am I correct on this? A capital case, crimes can include a death penalty. I don't think they're seeking the death penalty in this, but it could be. I don't know. I was looking at Georgia law. Let's see. In Georgia, Georgia's capital punishment law may be applied to defendants 17 and older for certain homicides, including, I don't know how far we're into the grape, armed robbery, I have to say grape, or against a peace officer, for example, as well as for airplane hijacking or treason. So you've got the armed robbery, which enables them to, which is what we're dealing with right here. I mean, it's literally an option for a death penalty. I didn't realize it was that severe of a possible outcome on this case. Cheryl Bybee, love this chat. Hey, y'all, 7 months. Cheryl, thank you very much. Thanks for the y'all. Love the y'alls. Let's see. AC's Wildflower and chat. While we wait, any suggestions for an app or a program for doing senior graduation slideshow? AC's, depending on the length and how much work you want to put into it. I've found that iMovie, first of all, iMovie on that is default software that's included on a Mac has some decent ability to do that, and you can do some minor changes as far as zooms. They call it a Ken Burns effect, where it will zoom or pan or scroll or move the picture, so it's not just a slideshow like a projector putting up a new image over and over. I like that one. As far as it's a good trade-off with how much experience you need to make it and how easy it works together. It's easy to add songs, build it together as long as you want several songs over and over or whatever. It's pretty good. Seems high for a robbery. It's the armed robbery part that Georgia is just takes issue with. So rape, armed robbery, or against a peace officer qualify you, as well as airplane hijacking or treason, qualify you for the death penalty. That's a Georgia capital felony. And because of that, because these are capital offenses, the closings are allowed to be 2 hours long. So in the short term, that's the sentence for us. There's a woman there on the defense side that I've not seen before. It's sitting in the gallery. Doesn't look like, not on the attorney's level. I think here's our defendant. Here's Mr. Pritchett. Yep. Judge is probably already on the bench. Let's see.
Ms. Rivers, are you ready? All right, we are back on the record in State versus Pritchett and Robinson. The jurors have returned from their lunch and are ready for Mr. Pritchett's closing, as well as Mr. Hiles's part 2 of the state's closing. During the break, I shared with the state and with Ms. Mignot the proposed verdict forms, which are based on a proposed verdict form from Ms. Mignot for Mr. Robinson. There are obviously 2 forms, one for Pritchett and one for Robinson. Mr. Hiles, any objection from the state to either of the verdict forms?
No objection, Your Honor.
Ms. Mignot?
No objection, Your Honor.
Okay, I know you like the Pritchett one more than the Robinson one, but you're good with both.
Yes.
Mr. Pritchett, any objection to either of the verdict forms?
No, sir.
Okay, then Deputy Gordon, if you would grab these from me and trade Mr. Pritchett one copy of that for the two verdict forms, and then one copy of that goes to Ms. Mignot and one to the state, and that is a final version of the jury charge based on all our discussions and exceptions, et cetera. I have in my hand the original that I will read to the jury later this afternoon, and which will go out with the jury during their deliberations. Mr. Hiles, anything else before we bring the jurors in?
Nothing further, Your Honor.
I will inform the jury that count 17 is no longer before them when I start my charge to them. Ms. Mignot, anything on behalf of Mr. Robinson?
Nothing on behalf of Mr. Robinson, Judge.
All right, Mr. Pritchett, anything from you? You ready for your closing?
Yes.
Great, let's bring the jurors in.
I wonder if that's Mr. Pritchett's mom. She seems nervous right now. And she seems she seems like she's watching closely. You might have family here. She looks like she's just intently watching Mr. Pritchett.
All around for the juror. President,
Thank you, Deputy Gordon. Everyone else can be seated. So we didn't speak directly, but through my proxy, Deputy Gordon, I learned you all wanted to do lunch first. So you've all dined, hopefully, at least you had your lunch break. We are back together, and there are 3 pieces remaining before you've got all the pieces you're going to get to the puzzle of the state versus Pritchett and Robinson. 1 is a closing from the accused, should he choose to do that. 2 will be Mr. Hiles's part 2 to the state summation, and 3 is the charge I must give you as to the law you must apply. So let me turn to the accused. Sir, do you wish to give a closing argument?
Yes.
Great. Now is your chance to do that. And I don't know where Deputy Gordon went. Do you mind? You went to the back. Deputy Gordon. Oh, you're on the radio. Deputy Gordon? Do you mind? We had to adjust the podium monitor when the defense one went out yet again. If you just rotate that. I mean, you were having like a seance or something back there. I apologize. You can relight the incense when you get there. All right, sir, when you are ready.
Esteemed members of the jury, I would like to apologize because I know I missed the opening and I was failed to introduce myself. My name is Max. Nothing more, nothing less. My name is Max. I'm not sure what the beliefs are of the jurors are today, but you guys may hear me quote the Bible and reiterate principles mentioned in the holy text. And I know some may think that this has no place in such a secular institution as this, but I would like to correct that by quoting from Public Law 97-280, which is a record of Congress and a stamp in legislative history. And it says, whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, whereas deeply held religious convictions springing from the Holy Scriptures led to the early settlement of our nation. Whereas biblical teachings inspired concepts of government that are contained in our Declaration of Independence in the Constitution of the United States. The quotes of President Jackson, the Bible is the rock on which our republic rests. Whereas the history of our nation clearly illustrates the value of voluntarily applying the teachings of the Scriptures in the lives of individuals, families, and societies. Whereas this nation now faces great challenges that will test this nation as it has never been tested before. Whereas the renewing of our knowledge of and faith in God through Holy Scripture can strengthen us as a nation and people. Now, therefore, be it. I say that to say, jurors, that today, in accordance with the Jews, it is a high holy day that is being observed, which is the Passover.
Objection. Relevance.
So don't make relevance again as an objection in closing argument. You may have others, but Mr. Pritchett's gonna, as long as he isn't straying from the record, he is free to bring in his thoughts and perspectives. So overruled.
Fact on evidence.
I will take judicial notice of the fact that this week, well, I don't know that it's this week, it had been last week, but either way, Mr. Pritchett, why don't you press on?
Okay. The title of these high holy days is the Passover and the Feast of Unleavened Bread. These days were to be observed by the Israelites forever. It serves as a reminder to them that God's judgment passed over them, but struck down the Egyptians.
Look at the state's eyes. They're like,
the Lord's judgment passed over these people because them and their families' households were marked by the blood. Jurors, my innocence, my adamant repentance, dedication, and love towards God has led me to believe that I am marked and been marked by the blood of the Lamb, Jesus Christ. I want to now just first, again, extend much gratitude for your service. You guys have showed me much patience and tolerance when I know at times I was unintelligible with my words. At times I displayed a great lack of legal expertise. And even at times I wasn't even present for some of the proceedings. It was never my plan to go through trial with no lawyer. Major conflict and ineffectiveness arose from previously assigned attorneys.
Objection. Facts not in evidence.
Let's not talk about any prior relationship, good or bad, you had with attorneys, okay? You're welcome to draw attention to the fact that you're representing yourself, but not about what happened outside the presence of the jury.
he has to skip a few paragraphs.
If cases were determined on who displayed the best legal charisma, I am aware I would lose. But jurors, as you already know, cases must be decided on if the state has proven every element of each charge beyond a reasonable doubt. And so I would like to iterate that I deny every allegation against me, and I believe you shall allow your judgment to pass over me, and a verdict of acquittal on all charges be established because the state has not fulfilled their burden of proof.
State's rolling their eyes.
The evidence presented to us by the state shows only that there is a lack of evidence, that they are missing to prove every element beyond a reasonable doubt. But what was presented shows us that there were two gunmen And according to the victims and the responding officer, Ms. Reams, that night, according to their descriptions, one male is a scrawny, skinny built, light complexion male. The other assailant, according to the victims and the responding officer, Ms. Reams, is a black male, heavy built and of dark complexion with a tattoo on their upper left arm shoulder. I have not one single tattoo. And it is clear that I fit neither description of the alleged assailants.
This is good argument.
From the deductions of the victims and the reporting officers, we know clearly that the state is not relying on this evidence to try and prove their case. We know that their argument and theory I say, is solely relied upon the testimony of Kalish and Riley. My question to the juror today is, what has either of these parties done to persuade you that what they have said about me is the truth? And even if you do consider their testimony, the fact still remains that every essential element of the charges against me has not been proven. There is no proof that I ever got in the car of Lauren Riley. There was no proof or evidence to prove I participated in any planning of such heinous crimes. Riley and Kalish do not know me from a can of paint.
Green paint.
There's no picture of me with guns or near any guns. And I'm not someone who used drugs. There's no motive for me to even participate in these chaotic crimes. Because of the many questions that the state has left unanswered, because of the lack of evidence, it can be inferred that Kalish and Riley may be protecting any one of the dozen of the gang members that were found in their phone records. Many of whom, according to the phone records, they were in intimate relationships with. Such as Monty, who they are scared of because, according to them, he has a lot of firearms. Or Young Bands or Supreme. The list goes on to who these women can really be protecting. And due to the purposeful lack of investigation into Young Bands, the state, as I reiterate, leaves many questions unanswered. Who knows what the real reason was that the state and Detective Maldonado chose not to pursue charges on Young Bands? We may never know. And I know. This is all speculation. This is all just inference. But the truth is, it cannot be factually denied or rebutted by the evidence that was been presented. Riley, in her first and second truthful interview, what she said with Detective Maldonado, never mentioned my name. In fact, she said she genuinely did not know the males. And again, reiterated that she did not know their names. At no point in this case did these two women say they saw me go in 1040 Wiley Street and rob a party. None of the victims said they saw me enter that house and horrendously beat and stole their personal belongings. If you even consider the portions of Kalish's testimony that she provided a couple days ago, it'll be shown that she lied to her mother on a call that she had with Detective Maldonado the day of her second interview where she told the truth, according to what she said. And she told her mother that she did not see anybody with any guns or mask. I know that when someone starts a lie, which she said she did at the moment she sat down with detectives, once someone starts a lie, the only way to keep up with it is to continue lying. And what better way to get the lie to be perceived as the truth than to get full endorsement by the State District Attorney Office of Fulton County, who promised them immunity. Excuse me. Ecclesiastes 3:16 says, "Moreover, I saw under the sun that in the place of justice, even there was wickedness." Now, I'm not saying that the state or the judge or any public official here or anybody is wicked. But I am saying that if someone is so politically motivated and fueled by their selfish ambitions, they leave the door for wickedness to creep in. We know that the evidence shown only truly shows a lack of evidence. And this lack of evidence has caused the state to reach in all directions to try and persuade you of their theory and its case. The state tried to reach in my past to try and pull out a previous traumatic experience of mine to validate their claims that are being made against me today. Did I plead guilty to that previous case? Specifically, I pled under Alford, which is specifically a plea that maintains your innocence. And it is only taken because you believe it was in your best interest at the time. And at that time, my older brother had just been murdered.
So, Mr. Pritchett, I'm not going to require the state to object each time. There's no evidence in the record what was going on in your family, tragic or otherwise, and there was no one who testified to that. So you need to limit your presentation to this jury to facts that are in evidence as opposed to things you think you may know outside the record that you've helped establish.
My options for sitting in jail for 3 years, last case, were to take that plea, go home and console my family through their grieving phase, or go back to 91 Rice Street, arguably the worst jail in the nation. So out of much distress and coercion, I chose the former option.
Coercion. Wow.
And so, yes, there may be some things that can be said about me for choosing that option. But I know, like I know now, I did not participate in that crime or this crime.
Eye contact.
And instead of the state producing clear, solid, and convincing evidence, they try to persuade you using my past. Of course, they didn't bring up my present, which is true. I have been locked up for the past 5 years, 4.5 years. But even then, there's not a disciplinary report that exists on my name. And as an ambassador of Christ, who is not under the law but under grace, I know the conduct I must keep and practice to finish this race of faith on earth. Am I perfect? Absolutely not. But the supreme wisdom of God has used false accusations against me to lead and align me on the path of righteousness and the purification of my heart so I can be a guide to the blind.
If the state's eyebrows go any higher, he's going to scalp himself.
The possible corroborating evidence that was presented by the state were cell phone records. But I would like to bring to your recollection that the state did not present any cell phone or even possible cell phone records from me to connect me to any of these accusations. And I say that to the fullest extent. There are no cell phone records or data before, during, or after that incident at 1040 Wiley Street that connects me to the crime or even any of the other supposed suspects of the crime. The state would try to say, I knew how phone records work because of my last case. And so they stated and made the claim that, that it was my motive to leave my phone behind. But again, they have not presented any facts or evidence to prove I left my phone, a phone subscribed to me, anywhere at any place. So many questions remain. And the weight of the doubt in this case against me surely outweighs the evidence. Why do you think I did not understand? To tell my story. Simple.
Just gotta be careful here.
My presumption of innocence has not been defeated. Again, so many questions remain. But with the lack of evidence in this case, we do know the answer of why these women would lie. That answer is they were promised and motivated by the state the opportunity to escape prosecution for this case, which is clear being that they were granted immunity. Ladies and gentlemen of the jury, the prosecution has even reached depths far unbeknownst to me as they tried to introduce photographic evidence portraying me holding a flag alongside acquaintances or friends, purportedly in a territory labeled as gang territory by the state. However, I urge you to consider this so-called evidence with a critical eye. First and foremost, holding a flag and a photograph does not equate to membership in a gang. The mere presence in a specific location does not automatically imply guilt or affiliation with criminal activity. How can I be in a gang and the state couldn't even show not one picture, not one video of me throwing up this gang's hand sign? Oh, that wasn't enough. How can I be in a gang when the state has not shown no evidence or fact that I even talk like and speak like one of these gang members? And I believe this shows the fundamental disconnect between this system and the people. And it has almost allowed this system to be degraded into a mere for-profit business. And his main customers, sad to say, are people that look like me. Let's not forget the Constitution and 13th Amendment still supports slavery.
Oh, where?
Again, I urge you to consider this so-called evidence with a critical eye. As individuals, we often find ourselves in various settings, some of which may be misconstrued and misrepresented by external observers, which clearly is the case with the gang expert that testified. Furthermore, the prosecution's attempt to link this photograph to the alleged gang involvement in the crime at hand is blatant misinterpretation of the facts. There is no concrete evidence connecting the activity depicted in the photograph to the events at the Wiley Street party home invasion. In fact, the state has tried to say that during that home invasion, a pair of shoes were stolen off one of the victims. And according to the victim's testimony, the shoes had a blue light. The picture was edited. And he said verbatim, the shoes were a highlighter yellow. According to that gang expert, the colors of YSL are green, lime green, red, and blue. I don't remember yellow ever being mentioned. I categorically deny any association with a gang or involvement in gang-related activities. My character and reputation stand in stark contrast to the criminal narrative painted by the prosecution. I am a God-fearing heavenly citizen, innocent of the charges leveled against me. And I implore you, members of the jury, to see through the prosecution's thinly veiled attempts to manipulate perception and construct a false narrative. The photographs presented as evidence holds no weight in proving my guilt. I ask you for your impartial consideration of the facts and your commitment to delivering a just verdict based on evidence and not conjecture.
Just reached the 25-minute mark on his closing. Reaching for the good book.
I can still smile. Highly esteemed jurors, do you want to know why I can still smile before you all today, even though I stand here falsely accused? It is solely out of my faith and knowledge of what Romans 8:28 states. And it says, and we know that for those who love God, all things work together for good, for those who are called according to his purpose. Furthermore, the very nature of this case raises reasonable doubt. A rushed investigation, the absence of clear identification, and the lack of any definitive proof cast a shadow of uncertainty over the proceedings. Can you in good conscience convict me based on such flimsy grounds? Lastly, again, let's not forget the presumption of innocence. It's a cornerstone of this legal system, a principle designed to protect the innocent from wrongful conviction. And I stand before you today as an innocent individual whose life hangs in the balance. The burden of proof lies with the prosecution, and they have failed to meet it. In closing, I urge you to consider the facts objectively. Do not let emotion or conjecture cloud your judgment. I implore you to uphold the principles of justice and fairness and to deliver a verdict based on evidence and not speculation. And not to forget the weight of doubt that lies in this case. I am innocent of the charges leveled against me, and I trust that you will see the truth. Thank you, and God bless you in the name of Jesus Christ.
Thank you, sir. Mr. Hiles, if you would set up whatever you need to set up.
Not what I was expecting. Kaylin, well, so far I heard 1, the guy even looks like me. 2, those aren't the colors of YSL Gang. 3, they stole shoes. 4, something about the Constitution. I'm convinced this might be my neighbor. Wow. I have never seen anything like that in court before. I do think he was fairly selective about what he spoke about. He raised some points I think that didn't help him. You know, acknowledging that he is in custody. I'm sure the jurors could figure that out, but look at the big screen. I wonder if we're going to get to see that or not. Is that for the music video? It's so rare that we get to see a pro se closing argument. Brandy Churchwell, I'm reading Brandy, and I'm trying to talk about Darrell Brooks, but Darrell Brooks didn't give his because he lost the right to do so based on his outbursts. But I don't think it probably would have been similar. I think he would have had Darrell Brooks given his full closing statement that he wanted. I think it would have had a lot of quotes from the Bible. We did have a little bit of anti-establishment sentiment in there. Man, crazy. I do expect the state to, the mods are handling things in chat. Let's keep it. Same rules apply. We don't change the rules for this right now. So everyone behave. Mods will take care of any problems. Did not go sov sit nearly what I thought could have happened. I think he could have, honestly, he could have used the accused part. He could have woven that into his closing. Instead of just saying, my name is Max, I think he could have said, throughout this trial, I've been referred to as the accused. He could have woven that together. Oh, here we go. Reset the timer.
Now I'm here to tell you why Calvin and Riley should be believed. At this point, it's clearly obvious that there was a home invasion, and it depends on who committed that home invasion. I wanted to first start with the idea of there were initial interviews in the lie. They were kids when this happened. older kids, but the college age kids. What do kids do when
camera
they
moves.
are confronted with facts that they'll get in trouble? Generally, they lie. The example that I can relate to when I was a kid, late teenagers partying, was stealing my dad's vodka and filling it up with water. I had younger siblings that were too young to be doing that type of stuff, but I did it. I put it back in the freezer, and when it came out frozen, I denied it until the stars came back. And that was how I was finally able to come clean, was because I was confronted with the actual evidence. There was no immunity given at the start of this prosecution. If you look at these immunity grants, they were granted in 2022, just before the case was supposed to go to trial the first time. What immunity means is that the state cannot take the words you say on the witness stand and use them against you. Otherwise, you would never have co-defendant testimony against another one, because you would be compelled to give evidence against yourself, which is a violation of your own Fifth Amendment rights. If that immunity is not there, and Ms. Riley or Ms. Kalish decide that she wants to take the stand, decides that they want to take their case to trial, then all the state would have to do is just replay the testimony that was given as they fingered their co-defendants as to what they were doing. Really what it comes down to is, where's the corroboration? How do we know that it was Pritchett and Robinson that went inside that house? Well, where does it start? It all starts at the Mayfair. It starts with Young Bands. Young Bands is Voss Coleman. The same Voss Coleman that defendant Pritchett planned a previous home invasion style burglary with. You heard the 911 call. You heard the evidence that got him called. Starts with the same people. 199th and 14th Street Northeast. It's called the Mayfair. This is the conversation that was pulled from Lauren Riley's Instagram accounts. We have undisputed evidence that this is their account. Also, this is where defendant Pritchett, Max, the one who just came up here and proclaimed his innocence, he was arrested at the same spot that it was planned. Again, corroborating what the two co-defendants told you. I'm going to go through this whole text thread too, because it's important. The messages are what corroborates what the girls told us. Just got back home, text me when you're on the way. This right here, this 678 number that we know is from Young Bands, that's the same 678 number that Lauren Riley is texting with in April. You'll have that text conversation, and I'll bring it up at the end of my presentation, but you'll be able to take that to the jury. That corroborates that Lauren Riley and Lindsay Kalish actually knew were with Young Bands and Pritchett, who goes by Rick. Undisputedly goes by Rick. Both Detective Velasquez in 2015 when he was investigating Pritchett, Rick Rare. Now his Instagram account, Rick Rare. That hasn't changed. So this is in UTC time, it's not accounted for, but the reply to this message is, are you alone? Young Bands asks, why do you say that? He says, yeah. Lauren says, because Lindsay is with me. What did Young Bands say? Oh, Rick's with me. He said he wanted her to come. That is Rick, the man that just got up there and proclaimed his innocence to you. Max and Rick are one and the same. That's the same individual that Lindsay testified having sexual relations with. You don't just pull that stuff out of a hat when you're trying to get yourself out of trouble. Lauren says she's parking. And then here's the most important question. Young Bands, he's known Rick, Max Pritchett, who he just said is with him, he said, Rick is with me. He's known Max since at least 2015. He is close. They planned at this point two, or almost to this point, 2 home invasions together, both of which were going to rob drug dealers. Lauren says that she's parking. And what does young man say? Okay, meet Max in the lobby. Max with 2 X's. There's not a whole lot of Maxes with 2 X's, but young Vans is the only person that you would think would be calling Rick Rare or Rick Max because of how long the relationship goes back. All right. So once Lauren and Lindsay arrive, they say they get a Snapchat. That's corroborated. Riggs told you he sent a Snapchat for one, maybe both. That's when the idea was floated. It is no doubt that Lauren, it was her idea. But when pressed, one thing Lauren did say was, well, how come, was asked, why didn't young Vans go? Lauren testified that he was on house arrest. This is why he was on house arrest. Big Slap. That name is not just pulled out of the air. In fact, what the defense got up here and told you is that they were going to prove to you, or they had shown you everything they were going to show you in the opening statements. But one thing that was said by the defense in the opening statements was, we are not going to run from the name Baby Slap. Client is Baby Slap. He's a rapper. You saw evidence of that too. But it's not just any random Baby Slap that they pulled out of the air as the defense makes you think, or wants you to think that there's thousands of them. This Baby Slap is directly connected to young Vans, to Pritchett, to the whole plan involved in this robbery. This is the testimony. The Snapchat was sent. The plan is made. Baby Slap joins the group. Lauren drives to 1040 Wiley Street. A whole lot of noise has been made about the fact that you never saw the 2 men get out of a car. How do we even know a car came? You've only seen one car circling the block. You never see the girls get out of the car either. It's because it's parked around the corner and it was unintentional. All right. Here's the video. Lindsay and Lauren going first. What did Lindsay say she did? Or Lauren said she sent a text message to Lindsay. She also said she deleted her text messages. What you see here is an empty file of an MMS message that was sent. Multimedia, that's a picture. You had to look for this actual HEIC number to get the image inside the records, but this was the image that was sent from Lauren's phone to Lindsay's phone, which wouldn't make sense if both girls were in the house together. The reason it was sent was because Lindsay's phone was in the car with Pritchett and Robinson. Baby Slap, Rick Ray. Lauren told us that she stole some wax. It makes sense exactly why she would switch jackets with Lindsay. Everything's adding up at this point.
Yeah. What do you guys up to? Oh, yeah, I do.
Everything she said happens is corroborated in the video. Here's the entry of the suspects. Pritchett, and Robinson. At that point right there, you see who I believe to be Defendant Robinson pull out an AR AK style pistol. And I'll tell you why you should know that that is Defendant Robinson who pulls out the pistol in just a minute. Clearly, the defendants were inside during this incident when she left. You can hear him say, "Bring out your phones." You can hear the beatings going on inside. Now look when they leave. See those bright shoes that everyone's talking about? They made a deal, tried to make a big deal about how do we know when shoes were taken? Did I see them? Did I not? Quite obvious that the person to be Pritchett, not Robinson, keep in mind these shoes right here that Robinson's wearing are very telling. But that's also the reason Pritchett keyed in on those shoes. That's the only thing he keyed in on this whole trial, because he knows what they look like. The brief clip of the Mercedes without the lights on. This clip right here is at 2:19 a.m. This is Mr. Vigris's, regardless, this is his system, his security system. Now, this is the correct time. You can see it displayed on the digital videos if you choose to watch these again. The timing on the other side of the house is exactly 30 minutes off from this. But we know this is the good timing based on when the 911 call was made. 911 call comes in just after 2:23 a.m. on November 8th, 2019. This is the aftermath. Mr. Gattani, he had his head split open, testified to his skull fracture. I put this in here because I want to make one thing, one main point when it comes to the aggravated battery against him. It says serious disfigurement. That's any disfigurement. You can't see it. Even if it's not permanent, it still constitutes serious disfigurement for the count of aggravated battery. We know a home invasion occurred. Blood on the floor matches everything that the defendants told us. Now, I really don't care that they were partying. I mean, it is a deal in a sense because of the heavy drugs that were involved, but there's been a big mess made about why we're not prosecuting. In order to prosecute somebody for drugs, you have to have the drugs or have to be able to prove beyond a reasonable doubt that these candies actually contain THC. Well, there was no drugs ever recorded, even if all the recovered, even if all the officers went inside, because these two defendants stole them. There's nothing there to prosecute. The evidence was literally the target of the armed robbery, the home invasion. I got these in here. This is the actual property each defendant said was taken from them. That's the basis of the armed robbery. Wallet for Mr. Carmody, wallet for Mr. Cooper, wallet for Noah Walker. Rebecca Mears had her phone taken. Jackson Buckingham, remember he testified he had four names. Buckingham and Kyle are one and the same person. It's just the Buckingham is what was on the police report in the indictment. It was actually Mr. Gattani had his, not shoes, but his phone taken, and Riggs had his computer taken. Lindsay testified that things were being thrown out of the car on their way home. And that, again, is what is corroborated as these wallets are found by people in the neighborhood. Cell phones are tracked down the street by the witnesses with the Find My iPhone app. And even I believe it was Ms. Mears said that a homeless individual actually picked up her phone and she met her somewhere around Woodruff Park to get the phone the next day. That's corroboration. Back to the maker. The testimony of Calish and Riley is that the edibles were all dumped out on the bed. They were promised that the drugs would be sold and that they would get a cut of the proceeds. And it's the conversations between Lindsay and Lauren in the coming days that is all the corroboration that is necessary for this case. They are naming Rick and Baby Slap and name on November 8th, 9th, and 10th, the day this armed robbery, the day and 2 following days after this armed robbery home invasion occurred. They're saying they're trying to reach out to young bands to get this stuff. We have that digital records. This is 8 days before they were even suspects. 8 days before. The police didn't tell them anything they didn't already know. And we know this because it's in the records. All right. I want to talk about this. What was it that was said by the defense? Oh, what a tangled web we weave when we first practice to deceive. When Detective Sluss came and testified, I entered these phone records, the T-Mobile phone records, correct? And that is what he spoke to, the call detail records. Detective Sluss, in his testimony, said, there are no timing advanced records. Timing advanced records are the records that tell you where exactly inside that little area the person is located when he calls. Well, when Detective Maldonado came to testify, the defense attorney put in DR-18 and stated, you have no records. This proves that there are no return of records. Any records you gave were a lie. But what the defense DR-18 says, it says, unable to respond to your legal demand for the following reasons. In regard to identifier 470-646-4757, no timing advanced records exist. She put this into evidence as proof that Detective Maldonado was lying about ever getting call detail records that have been admitted into evidence and talked about by Detective Sluss. Now, this 470-646-4757, this comes directly from Baby Slap's and Tyron Robinson's Instagram. It is verified. That means there was a text sent to that Instagram account that responded stating, yes, this is our number. Robinson Tyrone 999@gmail.com. All the identifying information. They were just cross-examined and how do we know which Tyrone Robinson this is? There's 2 Tyrone Robinsons. Well, we know because there was multiple days of back and forth where I was showing you how the linked media can be traced back to the PDF document that gives the exact time pictures and videos were posted. Those were undoubtedly pictures and videos posted by that defendant. Now, I cannot get up here and tell you anywhere in this little bubble exactly where the person who made this phone call was, the phone associated with Tyrone Robinson, because I don't have the timing advance records. But I do know, and from Sluss's testimony, is that a call from the Mayfair at 3:30, just after 3:30 on at 3:35 on November 8th, 2019, that would be consistent. That is the tower that you would expect a call coming from the Mayfair to bounce off of. That's corroboration. That's saying that after the robbery where the girls say they returned with the defendants, that's where the call, is consistent with the call being made from the Mayberry Packers. All right, the shoes. Look at the shoes. You can see the red in Mr. Robinson's shoes. I pointed it out when he was leaving after going into this home invasion. Go to the next slide. This is one of the pictures that was recovered on the phone that was taken from his person. That same phone having multiple text threads stemming from that 470 number we just discussed. It was taken off his person. Incredibly similar shoes. I would argue, I'm submitting that they're the same shoes. AR style pistol. Same shoes, that gun. We know that there were guns involved in this home invasion. That's not a question. We know that the defendant had that same gun. Again, multiple YSL members, each holding up a different YSL sign. The green flag next to the firearm. That same firearm going into the AirBnB. All right. Communications about the money. Lauren Riley through Instagram directly after the robbery where she said was playing at Vans' house, text Vans and says, "Are you even going to give me any of your money?" That's quickly followed up by she was blocked. Blocked by young Vans. He doesn't want any part of this crazy chick. They got the money, she's not getting any of it. This is the conversation that is all the corroborating evidence that you should need to understand why the girls are telling the truth. Why is these two individuals? They have not even been made suspects at this time, let alone questioned by police as to who they are talking about getting the money from.
Welcome, Special K. Thanks for joining.
Van said he needed to get the money from Rick.
You can
keep asking for the money. What you mean? Like, you need to keep talking to Rick until we get the money. Rick is Max Pritchett. His Instagram is Rick Rare. It's got his profile picture in the Rick Rare. And he was called Rick Rare all the way back to 2015 when he was part of the planning and execution of another similar crime where he went to rip off another drug dealer. So Baby Slap and Rick are still talking to me. That's good. That's on 11/9/2019 at 4:37:38 UTC. Subtract 5, so that's 11:37. Remember, UTC during this point, subtract 5 hours. On the 10th, can you ask Rick and Baby Slap where the money is? Lindsay responds, yes. November 10th, 2019. See, this is possibly, it is the most damning for Mr. Robinson, identifying him with the Baby Slap that Lindsay said she was talking to, who she believed committing the robbery with. These target numbers cannot be changed. It doesn't matter what you do. Cannot be changed. Lindsay, the text and the F word, there's a normal conversation about what type of hairstyle are you fixing to get. Lindsay makes some dumb comment about not being able to keep up white girls' hair. And then Lindsay, 2 baby slap. We need to sell that shit and get a big dinner because I need some crab legs. This is November 9th, 6:50 p.m. She's told to just chill. And then if there was any question as to whether or not this was baby slap's account, she refers to him by name. What's the word? Baby slap. Presumably in another attempt to get the money that only the YSL members are keeping. Only the YSL members. Robinson, Pritchett, and what you heard the testimony from JP Miller is that young Vance has been documented as an associate. He couldn't say that he's an actual member, but keep in mind, we'll talk about it later, you only have to be an associate of a gang to be part of a gang crime. This is the same conversation reflected in Lindsay's phone. Lindsay's phone, however, is already accounted for the Eastern time -5, but she says that it's the exact same conversation reflected. These girls, they didn't have time to make this up. They were kept in separate rooms at the interview room when they got to the police station for interrogation, and they were never allowed to communicate again. Can you ask Rick and Baby Slap where the money is? That's Lauren's phone number. Lindsay testified that Lauren was saved with Sugar Mama in her phone. It is the same date and time reflected. The video, Play Nasty, it's in evidence. You can watch it again if you need to. I don't feel the need to play a whole music video for you guys again. But look, it's literally filmed at Young Van's apartment, the place that this home invasion was planned. This is a screenshot from the video. You can see the same painting in the video. Throughout the video, it's filmed in night, but you can see what I believe is the 22nd floor, 20-something floor. You can see the views. You can see all the same artwork throughout the music video that you can see in the actual body camera footage of where Pritchett was arrested. These aren't some casual connections. Pritchett's name wasn't just pulled out of thin air. Rick wasn't just pulled out of thin air.
Welcome, 13th jurors. Great to have you join us.
Always in the mix and has been since 2015. Instagram. Remember this video right here?
They do this to torture us. Yeah, we have to keep the music down.
That is the story on the right side of the screen that was posted on Tyrone Robinson's Instagram account. On the left side of the screen is the picture that I showed yesterday, recovered from Tyrone Robinson's cell phone, that shows it is the same phone number, the same phone associated with everything, and the same number posting to the account. Now, what's even more telling about this picture, look at the name of the song that he posted about with Young Vans. It's Partner in Crime, literally and figuratively.
What was that noise?
We're getting into the membership. There was a lot said about,
they keep playing
oh man, it appears that you just took screenshots from one music video. There were several pictures in that phone dump that appeared to all have been taken at the video shoot. I'm not denying that. But what is clear is it was taken with known gang members displaying known gang signs with the gang colors. You cannot get away from it. Just an illustration. These are multiple pictures taken on different days out of Robinson's phone dump, all throwing up the YSS. Rick Reyes You can see the screenshot taken from Robinson's phone, and you can see the profile pic of Rick Rader.
Two defendants,
Rick,
armed robbery case.
bands, baby slap.
One defendant is pro se, one defendant has counsel.
The middle picture. I think this was all taken at the same gas station at the same time, but it is posted by on accounts of 3 separate known gang members. So I'm Santana, the middle one. Snake love all the time, slime love all the time, Slat.
Can somebody send me the link to Brandy's?
The name Baby Slat is synonymous with YSL. Look at the, we ain't with the rap shit, 1100 snake pit. We gonna take something. I had to tell my partner chill, because he gonna whack something. That we ain't with the rap shit, we're not just singing about this stuff. We're not just artists. We're out here in the streets living out what we're singing about.
I just sing about it.
Pritchett got up here. He is incredibly intelligent. I'm not going to deny that. It's a shame of what he's using his intelligence for. It is very sad. He knows from past experiences to keep his social media clean. You heard an exchange that he had with the defense about having multiple social media accounts from the first time he got arrested. He watched his friends go down in that same case because of their social media. What does he do? Lindsay and him were only texting over WhatsApp. That's the only way he would communicate with her. What did we hear about WhatsApp? 1, it's encrypted. 2, a single party can delete the entire conversation on their own from both devices. That's the testimony we received. He's got an education in the streets. He's done it before. He knows what will get you caught. Of course there is not any phone records putting it in the Mayfair or at the other spot. I don't even think he wasn't even arrested with a phone. We couldn't get a verified phone number for him. He walks smooth.
You say he walks smooth? It's like the modern version of trying to catch me
All
riding
right.
dirty.
This iron triangle, the gang, the person, the crime.
Zoom is reversed on this one. Sorry, guys. I don't know why it's backwards.
YSL is a criminal street gang. Investigator Miller himself has interviewed over 20 members. The person, I believe we've shown Pritchett and Robinson, their affiliation with the gang. Even if there's no pictures of Pritchett throwing up gang signs, he knows to keep his social media clean. But what's telling is who he is with and what he is holding. And if you don't want to believe that he is a member, that's fine. An associate, you have the gang count says member or associate. He cannot run away from being an associate of this gang, which when you commit crimes and furtherance of the gang, is just like you're a member. Crime. The home invasion, all right? It is executed, the actual physical home invasion executed by 2 YSL members. 2. What's telling is how does that benefit the gang? Well, only the YSL members got to share in the proceeds. The others were cut out. It is only the gang that benefited. Lindsay and Lauren thought they'd get a quick score, some money to fuel their whatever addiction issues they had at the time, whatever lifestyle they wanted to live. But that nexus, that connection to the crime, the gang, and the person, it's the fact that only YSL benefited from the proceeds of that robbery. I just spoke on this slide. not every detail needs corroboration with codependent testimony. That's impossible. You're never going to have full corroboration. You just need a slight corroboration. So how do you know that it is not just one person trying to get out from under being in trouble and lie their way out of it? Well, Lindsay and Lauren were caught. You can see the corroboration in their cell phone messages to each other. You can see the corroboration in their Instagram messages to young fans, to baby slapped. This is even before the police even got involved. Next couple slides, young fans. Speaking with Lauren prior. This is the same cell phone number, that 678 number, that same cell phone number that texted Lauren or Instagram. It was sent to Lauren over Instagram with the address to the Mayfair. That same Instagram message that said, Rick is with me, bring him over. Bring over Lindsay. This exchange. If you need something, call back. Nah, you're lame as fuck. Then on the 12th of April 2019, just after 3:07, so it's in UTC time, so it's going to be about 10 p.m. Just Rick, again, Rick, Max Pritchett, texting through somebody else's device. This isn't something new that we saw with the evidence gathered at the beginning of the presentation. This is something that's been going on for months. It's Rick. Tell Lindsay to call me. The same Rick that Lindsay admitted to a sexual encounter with. These girls love bad boys. That's what got them all. That's what drew them to this. But this isn't something new, and it's not something they pulled out of their backsides to get out of trouble. Now, they might have been pressed with irrefutable evidence of their involvement before they came clean.
Did he say pull?
And I'm not telling you that they don't have motives, that they hope they get treated better. I'd be a lie. They told you they did. But this idea of immune from prosecution, what they are immune from is the state using their testimony from only what they said on the stand against them. That cannot be played. Anything garnered from their testimony cannot be used to prosecute them for this case. Another thing that I want to point out about that order granting immunity. That's not a state granting immunity, that's the judge granting. Only the judge can grant immunity when it comes to the testimony in the court. That is his order.
He's approaching 40 minutes on his portion. I think we had, about 30 minutes previously, so he's 15 minutes more max.
Every single one of you knows what that is. It's not it's a picture of a $1 bill. Beyond a reasonable doubt is not above all doubt, beyond all doubt, as in that mechanism that the chart that was shown to you by the defense. It is doubt that is reasonable. The idea that you can't put Mr. Robinson or Mr. Pritchett in that car. We know that Lindsay and Lauren had to take a car from the Mayfair to where they were at 1040 Wiley Street. It's too far to walk. They didn't Uber. You see them, the car circling on the camera. There weren't any drugs or guns that were seen in the car prior to going to the house. Lauren testified that she saw a gun being placed into a backpack while they were leaving the Mayfair. And Lindsay said she didn't see any guns prior. There's no reason not to believe her as that bad. There's always going to be questions left unanswered. But an unanswered question doesn't mean reasonable doubt. You know beyond a reasonable doubt what this image is. The drugs that were dumped on the bed didn't just appear out of nowhere. We saw the two masked men go into the building. Whether or not they were wearing gloves or you could see their wrists, I don't think that all of the victims in this case, victims, even though they were doing some illegal stuff, they are still victims that were violently beaten. I don't think they're going to remember every detail about every person. One, being intoxicated. Two, just the traumatic nature of this event, let alone that they're up here testifying almost 5 years later. But what we know beyond a reasonable doubt, based off the evidence that we can directly see and what's told us, is that these two masked men go into a house, severely beat two individuals, steal shoes off of somebody's feet that are in evidence that are lime green shoes in the picture that was taken by him. The only shoes that were taken are these lime green shoes, highlighter yellow. The picture, you'll have an evidence, you decide what color they are, but they are undoubtedly the colors of that game. Another motivator for taking those shoes. It's even testified that as the individuals were leaving, the shoes caught their eye and they came back and took them. It's beyond a reasonable doubt. Now, Pritchett and Robinson, Baby Slack, Rick Rare. It doesn't matter if you see him getting in that record. You know they had to. That's the whole circumstance, circumstantial evidence that we've been speaking of. It's not some random robbery from some random people because it was posted on the internet. Snapchat's not public. It was testified that it wasn't public. Snapchats disappear once you send Snapchats. It's open and closed. Another estimate. Even if it was, it's no coincidence that Lauren, Lindsay go into a house, leave the door unlocked, and two armed men go inside. There's no other reasonable explanation other than the fact that it was Baby Slab, Rick Rare, who committed this. And one thing Lindsay was consistent with all this whole time and tried to be brought up, she said Baby Slap wasn't present for the planning phase. She never wavered on that. And it makes sense. It makes sense. Bands couldn't go because he was on house arrest. Still fighting a charge where a man jumped off the balcony from a home invasion. It all adds up.
That was close. That was close.
Baby Slap, Tyrone Robinson, Max Pritchett, Rick Rare, that were the two armed gunmen. You can see their complexion of their hands on when they go into the house. That color shot when they first go in on the video is consistent with the racial makeup as what was described.
His closing rebuttal is turned into a filibuster.
Pritchett's wide shouldered, especially back then. Nobody ever said they were fat. Built like a linebacker. Robinson, skinny. He's bigger, he's built out a little bit now, but you can see the pictures that were put into evidence. Everything's consistent.
The prosecutor almost mentioned that the previous home invasion had a fatality.
Footprint that we leave behind in the 21st century. And that, combined with Kalish and Riley's testimony, is what sinks them. It's what proves beyond reasonable doubt that it was Robinson and Pritchett that committed this home invasion, 7 armed robberies, aggravated battery, 7 aggravated assaults. Each person in there said that they were terrified that if they didn't comply, that they would be shot. imminent apprehension of great harm. This is real life Fulton County in which we reside. And I ask you to return to the jury room and return a verdict, the only reasonable verdict, which is guilty on all counts that are back there for your consideration.
And the plane is on the ground. I'm not sure if it's reusable.
While Mr. Hiles is removing that equipment, do a seated hokey pokey or something, because I need to read the law to you. It's not as interesting. There are no videos, but you need to be awake for it. So do whatever kind of seated yoga feng shui you would do. And I'll get this going over here.
Seated yoga feng shui coming up. Who's going to lead us in this one? So the judge can turn the camera a little bit so we can see the state. Okay, yoga's up. Here we go.
Okay. I now need to share with you all the law that you must, not may, but must apply to the evidence as you find it to be. This is it. You're going to have this during your deliberations. Unfortunately, I can't just hand it to you and say, please read as your instruction manual. I need to read it to you, which I will in just a moment. You're welcome to take notes, but you will have this document from which I am reading during your deliberations. It's also going to appear on the screen right there. Some people like to see what they're listening to as it's being read to them. So you'll have it visually now. You'll have this later. And I need to clear up one thing. This is the indictment. You will get this during your deliberations as well. I have removed one count from your consideration. Count 17 alleged the aggravated battery of Christian Riggs. And the allegation was that Christian Riggs' nose was seriously disfigured. That is not going to be on the verdict form. There's no more count 17 for you all to wrestle with. There's still an aggravated battery count. So I'm going to tell you what aggravated battery is and what the elements are, but no longer for your consideration is count 17, one of two aggravated battery counts. All right, let's see if we can get this to work. Indictment. A grand jury has indicted the defendants for home invasion, armed robbery, aggravated assault, aggravated battery, violation of the Street Gang Terrorism and Prevention Act, and possession of a firearm during the commission of a felony. All those counts involve both defendants. Defendant Pritchett is also charged with possession of a firearm by a first offender probationer. To these charges, the defendants have entered pleas of not guilty. And as I told you at the beginning of the trial, neither the indictment nor the pleas of not guilty, which are the signatures on the second page. And so you're not surprised. I signed for Mr. Pritchett. He declined to sign. And when a defendant says, I'm not going to sign, I'm authorized to enter a plea of not guilty, never guilty, but not guilty. And so I entered the signature for Max Pritchett. But neither the indictment nor those pleas of not guilty are evidence. The defendants are presumed innocent, and this presumption remains with them unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that one or both of the defendants are guilty of one or more of the crimes charged. The state must prove every material allegation of the indictment and every element of each crime, and I'll tell you what those elements are soon, beyond a reasonable doubt. There is no burden of proof upon the defendants, and the burden never shifts to them. If a defense is raised by the evidence, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove either defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. A doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your evaluation of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if that doubt does not exist as to a defendant's guilt, you would be authorized to convict. Evidence that merely places upon a defendant grave suspicion of the crimes charged, or that merely raises a speculation about guilt, is not sufficient to convict. It is my responsibility to instruct you on the law. That's what's happening right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence that has been presented. You must then apply the law I'm giving you to the facts that you find to see if the state has met its burden. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony and exhibits. Evidence does not include, as I've now said several times, the indictment or pleas of not guilty. It does not include anything that I've said or the lawyers have said or Mr. Pritchett, AKA the accused. And that would include their opening and closing remarks. And finally, evidence is not the questions that were posed. And that means questions that lawyers may have asked or that you may have written down. And I mentioned this at the beginning, the fact that you wrote down a question and maybe I didn't pose it to the witness is evidence of nothing, because questions aren't evidence. It's only the answers to the questions. Now, this evidence that you've received may be direct or circumstantial or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw that the light was red when the car went through the intersection. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. The classic example, someone walks in here with an umbrella and they're soaking wet. We can't tell, because my courtroom doesn't have any windows to the outside, whether it's raining or not. But that would be circumstantial evidence that it's raining. It could be that a sprinkler broke on another floor in the building, and that's why the person happened to have an umbrella and they got wet. But it is circumstantial evidence that it was raining. There is no legal difference in the weight that you may give to direct or circumstantial evidence. And in considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you may consider all the evidence you've received, the witnesses' manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. You may also consider any possible motive in testifying, to include any pending prosecutions or grants of immunity. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here in court to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You all have heard from expert witnesses. Those are people who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all the other witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is generally not required, provided you find the witness's testimony to be sufficient. But there is an exception, and that's an accomplice. And an exception to this rule about no need for corroboration applies when the witness is an accomplice to the crimes charged. The testimony of an accomplice alone is not sufficient to warrant a conviction. The accomplice's testimony must be supported by other evidence that supports an inference of the defendant's guilt, independent of the accomplice's testimony. The supporting evidence does not on its own need to be sufficient to warrant conviction, nor does the accomplice's testimony need to be corroborated in every material way. The supporting evidence must be more than that a crime occurred. It must be sufficient to connect the defendants with the crimes and must do more than merely cast upon them a grave suspicion of guilt. Slight evidence from another source that connects the defendants with the commission of the alleged crimes and tends to show their participation in those crimes can be sufficient supporting evidence of an accomplice's testimony. In order to convict, that evidence, when considered with all the other evidence, must be sufficient to satisfy you, beyond a reasonable doubt, that the defendants are guilty. Whether any witness in this case was an accomplice is for you to determine. Immunity. Several witnesses were granted immunity for purposes of their testimony at this trial. This simply means that nothing they said while testifying to you can be used against them in any prosecution, other than for perjury. This type of immunity does not mean that the witnesses will not be or are not being prosecuted for the crimes alleged in this indictment or for other crimes. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Sometimes evidence is admitted against one defendant and not the other, and I have identified those instances in this case. You may consider such evidence, if any, only as to the defendant against whom it was admitted. You have received evidence of a prior conviction of defendant Pritchett. You may consider this conviction only insofar as it may be evidence of one, that defendant's connection to a criminal street gang, and or the required element of being a first offender probationer for the offense in count 20, and not for any other purpose. Identification. The state must prove the identity of the persons who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, that you head out in the street saying, I'm going to do something that's illegal. It means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendants are not presumed to have acted with criminal intent, but you may find that intent or the absence of it from your consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendants are being prosecuted. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime unless the evidence shows beyond a reasonable doubt that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. You also may not find a defendant who merely associated with other people involved in the commission of a crime, guilty of that crime, unless the evidence shows beyond a reasonable doubt that the defendant helped in the perpetration of the crime or otherwise participated in the criminal activity. We're more than halfway there. Conspiracy. A defendant engages in a conspiracy to commit a crime when he, together with one or more others, agrees to commit a crime, and one or more members of the group does any act to bring about the object of the conspiracy. And a conspiracy is simply an agreement between two or more people to do an unlawful thing. The existence of a conspiracy may be proven by conduct, as well as by proof of an express agreement. When people associate together in an unlawful enterprise, any act done by one co-conspirator to further the conspiracy is legally the act of all the conspirators. However, each person is responsible for the acts of others only insofar as those acts are done to further the conspiracy. You may consider presence, companionship, and conduct before and after the commission of the alleged crimes in determining the existence of a conspiracy. Every party to a crime may be charged with and convicted of a crime. A person is a party to a crime if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises or encourages others to commit the crime. It is not relevant to your deliberations that other individuals who may have been involved in the planning or commission of the alleged crimes are not being prosecuted, or that only some of the defendants charged in this case are in trial. You are considering only the two defendants presently on trial. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Okay, we are now getting into the specific elements of the crimes that are charged in the indictment. In count one, home invasion is our first one. For home invasion, the state must prove that a defendant, number one, entered the residence of another person, two, without authority, three, with the intent to commit a forcible felony, a term which I will define, four, while in possession of a deadly weapon, and five, while that residence was occupied by someone with the authority to be there. Forcible felony includes armed robbery, aggravated assault, and aggravated battery. Speaking of armed robbery, for armed robbery, the state must prove four things. They must prove that a defendant, one, took another person's property, two, directly from the other person or from the immediate presence of the other person, three, by using an offensive weapon, and four, with the intent to commit theft. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if it is used against someone. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon. A firearm is a deadly weapon. Aggravated battery. Remember, we're down to one count of aggravated battery. For aggravated battery, the state must prove that a defendant, number one, maliciously caused bodily harm to another person. Two, by seriously disfiguring a part of that person's body. In deciding whether a defendant acted maliciously, please understand that malice in the context of aggravated battery is not ill will or hatred. You don't have to dislike the person that you committed an aggravated battery against. Malice in this context means simply the intent to cause the bodily harm without justification or excuse. It's not self-defense or anything like that. Malice also means willfully doing an act while aware of a strong likelihood that the harm may result. The defendants are charged with violating the Street Gang Terrorism and Prevention Act. One way a person violates the SGTPA is when he, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. Criminal gang activity means the commission, attempted commission, or conspiracy to commit any criminal offense in the state of Georgia that involves violence, possession of a weapon, or use of a weapon. And here, home invasion, armed robbery, aggravated assault, and aggravated battery all constitute criminal gang activity. To prove a violation of the SGTPA as it is charged in count 18, the state must show four things. Number one, the existence of a criminal street gang. Two, that the defendant is associated with that criminal street gang. Three, that the defendant committed or participated in the alleged crime. And four, some nexus or connection between the crime that was committed and the gang. Criminal street gang means any group of three or more persons which engages in criminal gang activity. The existence of a criminal street gang may be established by evidence of a common name or common identifying signs, symbols, graffiti, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Two more offenses I need to define for you. One, possession of a firearm during commission of a felony. This is a profound definition. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. It's the only felony where the title of the felony defines the felony. Home invasion, armed robbery, aggravated assault, and aggravated battery are all felonies. And again, firearm includes any handgun. And finally, count 20, possession of a firearm by first offender probationer. A person commits the offense of possession of a firearm by a first offender probationer when he possesses a firearm while on probation for a felony as a first offender probationer. That name is also self-explanatory. Home invasion, armed robbery, aggravated assault, and aggravated battery are all felonies. And as before, firearm includes any handgun. All right, now some operating instructions for you all as jurors. In the jury room, you will have these two verdict forms, one for Mr. Robinson, one for Mr. Pritchett. You should consider each count in the indictment individually as to each defendant. All but one of them charge both defendants. Count 20 is Mr. Pritchett only, but you should consider each count individually as to each defendant. Each defendant may be separately found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, you should unanimously find, beyond a reasonable doubt, that one or both of the defendants did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find that defendant guilty. And in that offense, the form of your verdict would be, we find defendant X guilty. And you would check that option on the verdict form for that offense for that defendant. And the verdict form simply lists each count that applies to that defendant. And for Mr. Pritchett's, which I'm holding, count one, home invasion, it says we find defendant Pritchett, and there is a blank and a not guilty and a blank and guilty. If you unanimously find Mr. Pritchett not guilty of count one, you check not guilty. Same for every other count for both defendants. If you do not believe that a defendant is guilty of a particular offense, or if you have any reasonable doubt as to that defendant's guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we find defendant X not guilty. And you would check that option on the verdict form for that offense for that defendant. Whatever your verdict is, it must, for a particular count, it must be unanimous. Your verdict must also be in writing, meaning on this form, signed by your foreperson and dated. Ladies and gentlemen, by no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of either defendant. I have referred to one of the defendants as the accused at his request. Your verdict must be based solely upon your consideration of the evidence, according to the laws that I am almost done giving you. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourself with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, this should not surprise you, you must not communicate with anyone outside your group, nor may you conduct any research. You have all the evidence you're going to get in this case. It's enough, it's not enough, it's conflicting, it's not conflicting. You work through that. It would be improper to supplement it with any outside information. To help ensure that happens, Deputy Gordon will be collecting all your electronic devices, to include Apple Watches, please. We'll hold them back in my chambers. I promise you'll get them back when you are done for the day. But while you're in the jury room deliberating, it's you and the evidence and your collective recollection. Finally, going forward, should you need to communicate with me in any way, for any reason, should you need to communicate with me for any reason, it must be in a particular way. It must be in writing. You got to write it down. Write out your question, your concern, whatever it is. Deputy Gordon will collect that. He's going to show you, I think you've done it before, how to make that light go on. He brings it to me. I share it with all the parties, and then I will respond with whatever response I'm allowed by law to give. And I caveat that because you may have a great question, and my answer might be, you know what? You're going to need to figure that out yourself. And you say, Judge, we wouldn't have asked you if that was going to be what you tell us. But there are times when I'm not authorized to give you what you're asking for. As an example, don't ask for the transcript of any witness testimony. You rely on your collective recollection of what witness X said. I will not be giving you a transcript of any witness testimony because it doesn't exist. That's it. I'm going to ask all of you but one to go back to the jury room, and very soon Deputy Gordon will bring you the jury charge, the verdict forms, and the indictment, along with all the exhibits that are going back for your consideration. There were a couple exhibits that you heard me admit as demonstratives, a couple PowerPoints. Demonstrative aids don't go back with the jury. So if you're looking for that gang PowerPoint, you're not going to find it, because while that is in the record, that will go up on appeal. If there is an appeal, it's not part of the evidence that the jury will be considering, but all the photographs and texts and this and that, or the whatever we call the Instagram-y back and forth, that'll be with you for your deliberations. Any logistical questions? When you need a break, you should feel free to break. You may not deliberate with less than 12. If someone says, I need to walk down the hallway for a little bit because it's been a minute, that's fine, and let that person or those people do that. But you deliberate as a dozen and not as 8 while 4 people are doing something else. Breaks are fine. You control the schedule for the rest of the day. We have to kick you out of the courthouse by 7. But between now and 7, it's your schedule. You finish before then, you finish before then. You don't finish by then, we're going to get together tomorrow. But you break when you want, and if you need anything, light goes on, Deputy Gordon zooms in and gets you what you need. And again, if it's a question or something like that, it's in writing, and I will respond as I am able. So if all of you, except for, I find my list, is Pickles, you stay put. It's good you're sitting in that last seat. It's like you had a crystal ball. The rest of you back to the jury room, start detethering from your electronic devices, or send that last text saying, I'm going dark. And we'll get you the evidence shortly.
All right. We've started the deliberation counter. It says we're at the end, so maybe the judge will take this down. Yes, he will. We get a full screen. Are you going to move the camera so we can see what's happening, Judge? That would be cool.
You all can be seated. You are our alternate. So what that means for the rest of today, at least, you're going to be in our other jury room. Deputy Gordon's going to show you where that is. There's a restroom in there. And I promise if we resolve the case today, we won't forget you. We'll bring you out. And we're going to see what happens. If this group is coming back tomorrow, I know you cannot be here in the morning, and you shouldn't be here in the morning. So we'll figure that part out. But for the rest of the day, I'm going to ask you to stay here. The one exception is you can keep your electronic devices. So if you brought something to plan for commencement, or whatever you got tomorrow, you may feel free to use it, but no outside research. I need you to stay limited to only the evidence that was presented during trial. If we lose one of those jurors, you join that group and they start over with their deliberations. You don't join them midway. They actually would restart everything they were doing, and you would become juror number 12. We actually hoped to have 14, so we'd have 2 alternates, but we had to release someone day 1. So any questions about that? Okay, if you have stuff back there, if you grab it, then Deputy Gordon will get you into that other jury room, and we'll just get you out here when there's some update, okay? Thank you.
What are those machines on the side of the desks there?
Mr. Hiles, do you have anything you want to get on the record before we go off the record, and then you and Ms. Mignot and Mr. Pritchett figure out what's going back with the jury?
No, Your Honor.
Okay, Ms. Mignot?
No, Your Honor.
And Mr. Pritchett? Okay, my policy is that all the thumb drives and everything go back with the jury. They won't play them back there. They don't have a way to do it, but that's their way to be reminded, there was this digital media, and if they want to figure out how to ask us to watch it again or look into it, they can do that. But we don't not give it to them just because they can't play it. So really the only thing that shouldn't go back that I'm remembering right off the bat would be obviously the 2 demonstratives. But if you 2 lawyers would start by going through there and then let me know what I need to mediate if there's a disagreement.
Oh, yeah.
All right. While the deliberation counter is counting up, we're going to do one more poll. First, I have to end the poll we had already, which is the outcome of the case. How do you think the juries will vote? Let me turn this down here as they're sorting that out. Baby Slat and Rick Ware guilty is 77%. Baby Slat and Rick Ware not guilty, 14%. Only Baby Slat guilty, 6%, and only Rick Ware guilty, 2%. And we did go with the all or nothing approach on that one. I can't really do much more. Yeah, Vicky, I got what you said. I'll reach out to you or text me on the burner phone or something. We'll take it off air. But every time is basically where we're at. See, I want to change my vote. It's too late. The voting's over. Let's get the poll on jury deliberation time. How long will the jury deliberate? Oh, we got 2 B's in there. Bonus. Let's see. First one is going to be, I'm going to put this as, 0 to 2 hours. How about that? That's very, very fast. Very fast. It's after lunchtime, so let's see. They took a lunch. They end at 7. It's 2:30 now. 2:30 to 7:30 is 5 hours. So let's say 6. Just for the record, 2 to 6. That would be today. We've got an option for tomorrow. And then got to think of something creative for the last answer. Hang on one second. Okay. I expect nobody to choose option number 4 because that would be terrible. That would be absolutely terrible. But here we go with the poll. Hopefully I spelled everything right and included all the right words. Otherwise you could mock me incessantly. How long will the jury deliberate? 0 to 2 hours? 2 to 6 hours? Hump day verdict, or Karen Reed finishes first. So there are your choices. And really hoping it's not number 4, although somebody's already selected it. So there you go. 4.5 hours would be the end of today. I said 6. They're allowed to go till 7 tonight. That puts it 5.5 roughly. Judge let him go a little later, I guess, before they kick him out of the building. I'll say this, Mr. Robinson has been almost stoic and still throughout this trial. Not looking at anything. Nearly a statue. Have you guys noticed this? He's not looking at his co-defendant. His co-defendant is, from what I can tell, not looking at him.
Oh, you just came through there. Okay. What's going on back there?
What is going on back there? I don't think they're looking at each other.
But Mr. Pritchett should stay out. He just needs to, if there's any concern about what's going on back to the jury, he needs to have a say in that. So it's fine for Mr. Robinson to go back. And Mr. Robinson, just so you know the way this process will work, anytime the jury has a question or anything that I need to share with your lawyers, you'll be brought out for that. So they're not going to come out back there and say, hey, here's what we did. If there's anything that I need to get involved with, your lawyer will be a part of it, which means we'll bring you out here for that. Okay? Pardon?
Something tells me these two don't get
see
along.
what goes back, and then he'll, just like Mr. Robinson, he'll come out here when there's a question. But no. Only they're sorting out what goes out with the jury, and he needs to be heard on that as well.
Look at Mr. Pritchett's body language. How much more movement he has now that Mr. Robinson is gone. Something tells me that that there's issue. There's tension there. Quite interesting if there's going to be a split verdict.
Thank you, Ms. Rivers. So we don't have to do it 6 times?
Yes. Good point. Trevor's always keeping us in check.
I'll bring it over to the defendant because he's acting as his own lawyer. He gets to participate as a lawyer would in all these steps. Now we have bad blood. Little Taylor Swift in the courtroom. Yeah, the white balance in this is really bad. It's not just the white balance is off, but the brightness, the iris is wrong. It's a poor camera. It's like a USB type camera, and it just doesn't have a very good color presentation. So anything that is anything close to white shows up as brilliant white. And it's just blinding. It's outside the broadcast safe region. We'll give them just a minute to get this done. I'm about to wrap up the poll. If you haven't voted, please do so now if you'd like to make your input count. Looks like we have about 377 votes right now. 78. 379. Do I hear a 380? 382. Oh, it's going fast. Okay. If you can't see the poll, it's up at the top, the pinned message at the top of the chat. It's a little harder to see on a TV sometimes.
Yes, is
That's the conversation.
Closings were both this stream and this morning. We had the state go first with a short closing focused mostly on the law. And then the defense for Mr. Robinson went second. We had a break, a lunch break, and then Mr. Pritchett, the pro se defendant, went first thing after lunch. And then the state with a rebuttal, very lengthy rebuttal, using basically all their time, I might add. I think, where were they at? I think they were about almost an hour, maybe just over an hour. Used every minute available out of the two-hour allotment. The filibuster approach, which I'm not a big fan of in a closing. I think at an end of a trial, first of all, juries are tired. It doesn't matter if it's a 1-day trial or a 10-week trial. The jury has an expectation of when it's supposed to end, and when they get near the end, they're ready for it to be over, even if it's just been one long day. And you don't want to be the last person talking, okay, dragging it out for the jury. I think brief closings are better that way. All right, we're going to close this. We've got 440 volts in. Closing it in about 10 seconds. That way, that's about the delay between when I say it and it happens. Anthony B., I got a summons for federal jury duty. That's awesome. All right, here we go. Closing the poll. 3. Oh. Now all the votes come in. Like 7 of you voted in the last 10 seconds. Okay, we're closing as soon as we reach 450. 449. One more vote and we're good to go. 450, it's closed. All right, how long will the jury deliberate? 2 to 6 hours, 54%. A hump day verdict, 24%. In the first 2 hours, only 18%, and KR finishes first. A couple of you voted, 3%. 3% thinks that Karen Reed finishes first, which would make this deliberation, what, 8 weeks long? Is that what you're saying? It's a long time to deliberate. Should have put Sarah Boone goes first. Pamela, I'd like to cover the girls' trials. We'll see what the schedule is and what's happening at the time.
I just want to know what's going. You guys do what you want.
We're done with what's going.
Okay.
Not yet, not yet, defense. Mr. House, you have a 34 and 38 over here, the demonstrative. Yeah.
So I did hear Brandy's rap that 80s Music Man put together. It's pretty good. It's pretty good. I like how it gives Lucy a little bit of time in there. You know, the walks on the beach. It's got the charts are obviously referenced prominently. I think it's only appropriate that I mix up a response. I'm not going to play it here, but I'd like you to hear it. If you want to hear it, it was about 27 minutes, I think it was, 27 minutes before Brandy's stream ended today. She played it. 80s, you did a good job. It was good. It was thumping. I think Brandy enjoyed it as well. I think she said she was going to make it her ringtone. So we have to have a rap battle. I know there's a YouTube channel with the epic rap battles of history, but ours is going to be like epic rap battles of LawTube adjacency. Let me see if I can drop a link to Brandy's stream.
So 1 through 4 interviews. I don't remember the interviews being admitted. I'm not saying we can't do it now. It don't have to be.
I think Mr. Abadi stipulated to him.
Oh, that's right. That's right. He did, so that we weren't going to necessarily. Yeah. So that way you could ask either Kalish or Ryan. Yes, they're in. So 1 through 4 and their subsets are all in.
So we're the judge. We have all the evidence.
Okay. Well, let's get on the record, Ms. Rivers, real briefly. We are back on the record in State versus Robinson and Pritchett. Mr. Hiles, do you agree that what is in that illegally retained United States Postal Service bin constitutes the evidence that ought to go back with the jury?
Does that make me an accomplice?
What?
Yes, I do agree.
All right, Ms. Mignot.
That's a felony.
And Mr. Pritchett.
The judge just admitted to a felony.
You're not an accomplice either. We'll tape over that. I'm handing to Deputy Gordon 2 verdict forms, the indictment, and the jury charge. And the jurors are underway. If I could have a
15 minutes later.
Mr. Howes, if you would write on here, and then Ms. Mignot, 1 phone number that will get you and Ms. Blake back here. We'll get you back out here, Mr. Pritchett, anytime there is any court activity.
Okay, the judge referencing that the illegally retained
being recessed
U.S.
till then.
Postal Service box. Those plastic bins, which are super durable, they're amazing. I used to use them when I shipped a lot, but you can go to the post office and ship a lot of packages, and you can say, hey, can I grab a couple bins? Because that'll help me be able to transport these. And I'd have some, but you're not allowed to use them for anything else. It's a lot like the priority mail envelopes, where it's a crime to use them for in some other manner other than their intention. Oh, it's federal property. All right, I'm going to post the link right now for Brandy's. So I expect the viewership to plummet for just a minute, for a couple minutes. Well, everyone runs over to Brandy's. That link takes you right to the timestamp when the rap starts. So that'll let you listen to that. That's something that 80s Music Man put together for Brandy. Awesome job, 80s Music Man. Brandy's awesome. We love her. But that link will take you right to that moment. I'm not going to play it here, so you have to go watch it there. Got to go watch it over there with her so you can see her reaction as well, because I thought it was really neat. And then feel free to join us back here as we continue with jury deliberating discussion. All right. I like that he keeps the little window up in the corner so we can see what's going on. Let's reset that one. What's my opinion on this trial? I think I'm going to say there's enough circumstantial evidence here that I can convict. And it is circumstantial evidence that takes us there. Like the judge said, the testimony of a co-accomplice alone is not enough to convict. There has to be corroborating evidence, and there was that. The stories they told, even before the state had done the investigation and found all the information, matched up. So we knew that they were telling the truth. At least once they started telling the truth. So I just think it's there. I think it's good. It's solid for me. Like it or not, I mean, we typically don't see, the 403B and what do they call it? The prior acts coming in, right? We don't see prior acts coming in, and Mr. Pritchett's case, it did. We have evidence that he was convicted of a prior act of a home invasion robbery. In that one, we know, the jury doesn't know, but we know that the victim died in that robbery because he jumped off a balcony to escape the home invasion, and the jump from 3 stories was fatal. You hear all the facts on that, and Mr. Pritchett was out in the car, and it wasn't participating because he had a hurt foot or something like that. He's still an accomplice. So he wasn't the guy with the gun or the guy driving necessarily, but he's still an accomplice, and he does, as a participant, he's treated as a principal. So, and in this case, in Georgia law, that's allowed to come in. So we got the prior acts. That is something the jury can consider. And witness said it was a homicide. He did. The jury is not on the screen right now. That's a picture to show what jury deliberations look like, or may look like. But that's not our jury. I can tell you that because we've seen our jury every single day of this trial. The judge shows them. Anyway, so with that, I would say that the circumstantial evidence, along with the evidence of the co-conspirators, the 2 girls, and the evidence that we've heard of just all the little pieces, the phones being thrown and found on the ground, and for all the people's phones and wallets and everything, it just added up to me. The story made sense. What the girls were telling me made sense, and I believe that it's there. I think the gang affiliation I'm not sure if they're official members or just affiliated with the gang, but I think that's there as well. So I would say I'm in the guilty category when it comes to both these defendants. Let's see. I just don't believe the girls. Vicky, you've got a good reason. There's a good reason to discredit their testimony, right? Because they are literally charged with the same thing, and their testimony here could benefit them in their own trial. This is like the same scenario as a jailhouse snitch, where they're like, hey, if I tell you what this guy said in jail, maybe it will help me get my sentence lessened. You have to weigh that. But to me, the fact that they provided all those details that matched up the other evidence, that matched up the Ring doorbell footage, which they hadn't been shown yet, it seems to me that they're telling the truth, and I believed them. It was an awesome rap. Welcome back from the rap song. I agree there's enough circumstantial evidence to convict, but I think there is a chance of acquittal if the jury was persuaded by the Shaggy defense. It's the only part that really points the finger at them is the girls. So that was the weakest part. It did seem weird that we have firearm offenses and a gun has not been introduced as evidence. The closest we have is some rap songs where I believe what looked to be real guns were displayed. I said they look to be real because the way they were being held, in addition, first of all, they all look real. Okay, you can have a fake gun that looks real, but the way they were being held, with everything from the perceived weight of the gun, just from how they're holding it and the grip on the gun, and everything else, it just seems like if they weren't real, they're very good imitations, very good fake ones. I don't think Georgia has a law that allows this, but oftentimes in some states, when you commit a crime with a fake gun and use it pretending it's real, the crime is considered as if it was a real gun because the victim doesn't know the difference. Jury instructions did say something about co-conspirators. We heard that part. We know one of the girls has got her certificate as a paralegal, something like that. She's going into law while she's still facing it. We had a pink elephant to the thumbnail. Let me take a look at the thumbnail really quickly, see what we have. I'll tell you that right this very moment, my wife is at Lowe's buying some lumber we need to finish the bathroom, because apparently you can't just put the shower into the bathroom because we've completely remodeled the bathroom. You have to have like a framework behind it to like firm up the shower, because it's a stand-up shower with one of these. It's got like a sliding glass half circle door thing, and apparently because it's like a shower insert, but it's a 3-piece, and to build it you have to have a frame behind. I didn't know that, so I was ready to just stick it up against the wall, but I need to build the framework first. All right. Airbnb Gone Wild is our thumbnail. Bring it up on the screen. Going really slowly. Box 4 is 3. Can you see that now? There we go. Okay. All right. We have. Make this a little bigger. Oops, that's the wrong one. Shrink that down. There we go. I'll turn me off. In the corner, we just have the computer and the shoes. There's nothing I'm covering. So we have the hall pass for the lawyer who wanted to go out on break. Valerie, we have our first tenant coming this week. We're hoping everything's good. We forgot to have a cleaning fee on, so the first tenant gets a steal of a deal. No wonder they were all fighting over it. We had like 4 people fighting for those same dates. We've got the cell tower. Let's see what else we have here. The plane that the boys had to catch. You've got the menu from the lunch the judge does. We've got the title up here on top. We've got the co-counsel for the defendant who once claimed that he had a member of deity supporting him. I'm not sure about this certificate. Was that the law clerk's certificate for one of the witnesses? We've got the DJ at the party, Airbnb, slime, some curse words going on. The 2 girls, friends, security camera, ring camera, caught everything. We've got the goat. The goat is here. I can't remember what the goat was for. Crabs. One of the girls wanted money so she could go out and eat some yummy crab legs. Rapper. Mix it up there on the rooftop there. Cindy Collins, welcome. Yeah, I heard Karen Reed was crazy today. Welcome. Thanks for catching up with us. We're in verdict watch right now. We're just explaining the thumbnail for this trial. Let's see. More slime. We've got the witness who sort of peeked during the home invasion robbery and was looking through his fingers to see what was going on. We've got a basket full of something that I have no idea. What's the basket for? My boss's Airbnb I help manage has a cleaning fee of $200. That would be nice because we do the cleaning. I think our cleaning fee is closer to $50. Let's see. Spin the wheel. It's like Wheel of Fortune, but they were playing the games they were playing in this party, which had at one time 1 girl and 11 guys. It was interesting, the things they had on there. One of them was take a shot. One of them was remove an item of clothing. Interesting. We've got get out of jail free. Amber, you told me what that was, and now I still can't remember. What's this one here? Oh, Asian glow up there on the rooftop. Full stop. Don't know what full stop is for. Snacks. Basket of snacks. Okay, basket of snacks was for the jury. K is for, I think it's for ketamine. Clearly, we've got a pickle, big deal. Maybe that has to do with the fact that we made a rap song during this. Devil's lettuce is down here. We've got ham sandwich, which could be used to refresh a witness's both recollection and their energy level. Empty water bottle also goes with the hall pass. We've got lost phones, the gummies, the robber with wearing the mask, the bunny ears. Not sure about the bunny ears. Hip hop. The dentures, the false teeth. Well, it was actually Invisalign, but false teeth work. So we've got the laptop that was stolen, the green sneakers, or the Nike Off-Whites. The snake. Not sure what the little face is for. Let's see, the wallets. We've got all that. Let's see, the circus. What was the circus? And boost your immunity. I'm not sure about that one. Immunity. All right. Oh, yes, immunity. Immunity was for immunity. The girls had immunity. What was the circus for? Judge should say full stop. I am trying to get all the thumbnails onto dog tags. That's something I'm working on. Crystal ball. I'm not sure if you have a crystal ball. I think the judge said at one point. We don't have a pink elephant yet. And not sure what that is. Phone? Do we add a pink elephant? Let's see if we can bring something on here. Where's a pink elephant? It's a little too real. Let's do something more graphic-y. The elephant's right there. Oh, that is the pink elephant. I called it the circus. I'm sorry. Thank you very much. It's literally got a pink elephant on the top of it. Okay. All right. The circus is the elephant. I got that. Is the face for the purge mask? Thumbnail needs Romans 8:28. Okay, scripture reference. We need slippers. The accused was wearing slippers today. Called himself Max. Just Max. It's a brilliant thumbnail. It really looks absolutely fantastic. Let's see, where's my mouse? Let's do this. Let's share. Download. I only need one page. This one. Current page 1. I need it in PNG format. It needs to be compressed so it's less than 2 megabytes. And download. There we go. All right, we are back on the jury deliberation. They've gone 32 minutes, or about 15 minutes once they had the evidence. The purge mask is on the pant of the leg of the robber. Okay, that was the knee. I wasn't sure what that was. I've never seen purge, so. We do have 2 dog tags ready. I'll make a couple more trials available with the other dog tags if you would like to collect all of them. That's an option. We'll get that built. We have great artists. For those that don't know, I made the first couple thumbnails, and then I opened it up for all who are interested in participating and contributing to the thumbnails, and it's been epic. You guys have done a really good job. I love the fact that we have obscure references to items. It really helps me remember the cases and the different facts of the case. We're not trying to mock anything in the trial, but they're brilliant. Bunny ears was for the gang signs. Remember the bunny ears part of the hands? Okay, got that, Amber. I see you're abusing the buffer option. That was supposed to be a last resort. All right. Dog tags with thumbnails printed on. Yes, that's what they are. They're the dog tags with the thumbnail from the court printed on it. All right. There was a brief police chase, but I was gonna put it on the screen. It was during the state's closing even, but immediately as soon as I pulled it up on my screen, they bailed and there was nothing else to see. They went inside a building. Nobody saw anything. Let's see. I'd have to look on the YouTube page to see what we already have. Just one second. My merch page is not working very well. YouTube's always been a mystery for me this way. Okay, we do have the Rust trial. We have the Trooper North trial. Those ones are ready. I think I was trying to make a cheaper version of the dog tag. I mean, I know it's metal and it comes with a chain and all that, and it's really cool, but I was seeing if I could find a cheaper one. I'll have to keep looking. Let's see, do we have Apple River? You just have Rust and Trooper North. But I've got all the thumbnails, so we can do them. Ivan, welcome. Says I've been a bit scarce, but I'm finalizing new legal biz venture. Love y'all. Also, I'm still waiting for thumbnail invite. Okay. Well, next trial, I'll put it out. It happens early in the trial. I release we try not to flood it with too many people, but are you in the studio? Sometimes it's easier to search Google YouTube studio thing you're looking for. Yeah, I'm actually in the vendor who produces them for me. Do you ever plan to allow a call-in panel again, or was that too stressful with the people being live? It was very stressful, Nova. It was super, super stressful. Between a little bit of off-the-rails discussions that go sort of outside the lines and have to constantly steer it back, it was tricky. It was very tricky. No, I'm in the rap studio right now. I've got lyrics pulled up on my screen in front of me, which looks like this. These are some of the words that I'm just piecing the parts together, filling in some blanks, trying to get the timing right, making a few subtle changes. But I have some one-liners in here that'll just blow you away. They're so good. The lyrically, it's brilliant. We do have a panel coming Thursday night. That's the next panel that we have planned. It's going to be on the podcast. It's going to be awesome. So if you ever want a police officer and an ex-principal to weigh in at the same time, and funny guys at that, we're going to do that. And Thomas and I will be there as well. Second album will take a while. Oh man, Cavalcante was crazy. I was thinking about doing that. I was thinking maybe there's another big event happening that we should cover. And all the big events that are happening around the nation have strong political connections. So, I mean, there are protests and things, but we can't go there. We just can't go there. It would just get crazy in here. Pond Walden, this case is that we're in. Oh, sorry, I need to show you the timer. That we're in deliberation for. Jury's deliberating, has been for just under an hour. This is a Airbnb that was, well, it was a rental that was sublet as an Airbnb, and it was rented as an Airbnb, or booked as an Airbnb by somebody who threw a drug party, and that drug party was the target of a home invasion robbery by alleged gang members. So it gets a little weird. We thought it was about the Airbnb, but we learned a ton. We learned a ton about gangs, and in the course of that, we listened to rap music, we watched rap videos, and we were so intrigued by the whole lifestyle that we went ahead and made our own rap song. I wrote a rap song clearly because everybody's doing it apparently. And yes, the other channel, Politics Not Pickles, never runs out of content. I'll tell you that much. So much is happening. So we wrote a little rap song. It was fun. It was way too much about gangs. It was like a gang trial. Master Eden, thanks for gifting a membership. That one went to Cali Girl 15. Congratulations, Cali Girl. Thank you, Master Eden. I was stressed for you. Yes, the panels are very stressful because honestly, just from a logistics standpoint, opening up a live channel for people to just connect and put something out there on my channel is a huge risk. I've even had legal advice advise me not to do it, but using the format that I was using, I was able to screen some things a little bit, and I felt comfortable doing that. But still, it was very stressful knowing that if at any moment somebody might do something that could jeopardize the well-being or even the existence of my channel. And as well that oftentimes the conversations don't go the way I would want them to be conducted on my channel. So it was that part was stressful. That's why I call that format Zoo Radio. It was nuts. It was fun. I loved seeing faces and names and things, but I think I developed like 6 ulcers during that. Lynn, thanks for the good word. The good words. I know all the time I lurk, but this is the best channel when I'm working. The chat and Recovery Addict give me a giggle, and stress is gone. And back to lurking you go. Gashat says, I can advise how not to look like a jerk on the internet. We did do 2 polls. We came back. I think the majority are leaning guilty on this one for both defendants, in this case, 2 defendants. There are actually 4 people that were involved in the crime, according to the police, and 2 boys, 2 men, 2 women, 2 boys, 2 girls, however you want to view that. I think they were all adults legally, or are now. I know they are now. But they're being tried separately. So the 2 boys together, possibly the 2 girls together. Maybe you should do a Meet the Mods stream. We've talked about this. I'm not sure if the mods would like to do it. Some of them love to do what they do, but are not interested in being on camera. So we'll see how that goes. If I could twist their arms nicely, I would do that. All right. Is that the jury at the table? Yep, that's them. Let's see if they hold up a card. No, I think that is a jury deliberating, but it's in a weird like conference room setting. Let me see. Oops, I just faded out to black. That's a good way to end the show. The thing is, they all have their phones out. They all have phones. They shouldn't have phones. We did watch the spicy Judge Simpson thing from the other day. I think we saw all of that, didn't we? It's the meeting room courthouse. The only picture other than me down here in the corner that's live is the top right-hand corner picture. That's a live view in the courtroom. So if that image shows a little activity, people coming back, the defendant, things like that, that will indicate that we can expect either a question or that the jury has reached a verdict. Mods can use avatars. All right, let me see if there's while we're waiting on this one, let me see if we can bring up. See if we have some other cases going on that we could pop in on, like a Judge Boyd, not Boyce, Boyd. Dream and Landry, first of all, somebody was asking about you earlier today. But yes, we did watch live yesterday that hearing in that trial. The state decided not, or I guess the county decided not to re-prosecute, that they were not going to retry him. And so they were filing a motion to dismiss the charges. The defense has asked for the charges to be dismissed with prejudice, meaning that it cannot ever be refiled. But this defense also asked and received an order from the court ordering that the sheriff's office, the police department, everybody who has any of Mr. Kelly's property relating to this case, meaning evidence, that it be returned to him. And that was granted. So let's see. Kansas. Got court in Kansas, possibly. Judge Wolf is not live. Judge Boyd is not live. Judge Simpson is not live. Man, we're striking out. Let's see what's up in Thurston County. Let's see what's happening up there. Okay. Court 2. Court 1. 3. Not seeing anything big going on like a trial. Let's try court 4. That one's usually. You guys, it is sparse out there right now. There's not a lot happening. Let's jump in and watch what happened about 20 minutes ago in court in Thurston County. Just while we're waiting, it'll give us something to watch and talk about while the jury deliberates. We have audio. I'm going to set up. Ooh.
Please rise.
Be seated, please. All right, Mr. Swenson.
Thanks, Your Honor. We are ready on Alexander Katermas, who's present on Zoom. Or was?
Yes.
Still there?
I don't see him. I don't see him logged in currently.
He was there for a while.
We just lost a couple people. Well, while we're waiting, Your Honor, if we could call Dominic Dolinsky on the 1030.
Okay. And then is Mr. Dolinsky here?
I'm waiving his presence. He was present on Zoom. I spoke with him and he authorized me to appear for him under Rule 3.4, Your Honor. Defense is asking for a brief reset. We have trial set for next week. There's an interview scheduled for tomorrow with the alleged victim. I want to depending on how that goes, Your Honor, could change how we proceed here. So I think both myself and the city just would like a brief 2-week reset if possible. I did file an updated motion or speedy trial waiver with the commencement of today, which would put us out to July 29th.
Okay. Mr. Sharp?
Yeah, that's the plan, Your Honor.
We're watching the courtroom.
We haven't quite confirmed the meeting time, Mr. Swenson. I'm optimistic. It sounds like it should work, but that's the plan. So no objection.
All right. So a short continuance would be, say, May 29th for trial and May 21st for confirmation.
That works for defense.
No objection.
Okay. All right. So May 21st at 10:30 and trial May 29th and 30th. Okay. So good cause and speedy trial waiver. Okay. Mr. Swenson. Looks like you got Mr. Katermas back.
Oh, there. Yeah. Mr. Cattermas is back. We can handle his matter, I believe, on the 10 o'clock. Yes.
Okay. So we have trial confirmation on the 435 case.
Yeah, Your Honor, Mr. Cattermas intends to change his plea today. There should be a statement of defendant on plea of guilty in the court file.
All right, and this is a plea to trespass second degree. So is that an amendment?
Yes, Your Honor.
Okay. All right, Mr. Cattermas, I've got your plea statement here to trespass second degree. Have you reviewed that with Mr. Swenson? Okay, and you're waiving your rights by pleading guilty, so that means you give up the right to go to trial, to have the prosecutor prove the charge beyond a reasonable doubt to a jury, the right to call your own witnesses to testify in your defense, the right to hear witnesses who testify against you and question them. You give up the presumption of innocence and the right to appeal your conviction. Do you have any questions about those rights?
No, Your Honor.
All right. The maximum sentence is 90 days in jail and a $1,000 fine. I see a recommendation here, but you need to understand I don't have to follow it and could impose up to the maximum sentence. All right. Did anybody make any threats or promises to get you to plead guilty?
No, Your Honor.
And the statement that's written on your plea form says on February 8th, 2024 in Lacey, I entered the Nisqually tow yard unlawfully when I should have known that I was not allowed to be there. Is that your statement?
Yes, Your Honor.
The tow yard.
Then I'll accept your guilty plea.
He's trying to get his car back.
All right. And Mr. Sharp, anything further to the city's recommendation?
Yes, Your Honor. So we also have a backup case. I'll just address them both here. I think the parties are agreed as to the sentence recommendation on this case. It's the sanction issue on the probation violation where we differ.
Okay.
Mr. Swenson and I have discussed this quite a bit. I certainly appreciate where he was coming from. The city originally was planning to ask for some jail time as a sanction with EHM authorized. Mr. Cattermas, unfortunately, has had a long, bumpy road on probation with Lacey with quite a few violations over the years. Mr. Swenson did share some information, though, that sounds like a good basis for optimism and that he's getting on a good track, so he doesn't want to interrupt that. But we still do need to address the issue of there being a serious probation violation. So the city's requesting substantial community service today, something on the order of maybe 40 hours, but giving him quite a bit of time to do that, maybe through the end of the summer. City's approach here is holding him accountable for the probation violation, which was a new law violation, without interfering with any treatment programs or other rehabilitation he's got underway, but also recommending the community service as itself a form of rehabilitation. So that's the city's recommendation here.
All right. Mr. Swenson?
Thank you, Your Honor. I would ask the court to follow the agreed recommendation on the plea. And with regards to the sanction, I appreciate the city coming down to community service from jail time. We have discussed this, and Mr. Cattermas has the ability to do community service, Your Honor, but my request for no sanction has to do with not wanting to set him up with further obligations that he may not be able to follow through with. He's in treatment right now. He's doing very well in treatment. He's been doing well for quite some time. He's hopefully going to be finishing that program soon. He is working, Your Honor, part-time, has limited resources. I think if the court is to impose community service, I'd ask for it to be less than 40 hours, but give him some time to do so. But I want to note that the underlying offense here is from 2019, I believe. This new law violation is not related. I believe that was a protection order violation. The facts in this case, Your Honor, are that Mr. Cattermas entered an enclosed space, a fenced tow yard. There was a giant hole in the fence that was potentially leading to some evidentiary issues that Mr. Sharp and I discussed, but ultimately we didn't want to take it to trial and risk taking this to a jury. But I think Mr. Cattermas, and as I mentioned in the plea statement, he didn't directly know that he was trespassing, but he should have known based on the fenced enclosure. So For that reason, Your Honor, the nature of the underlying offense and the time that's passed and the fact that he's doing well in treatment, I'd ask the court to consider no sanction.
All right, Mr. Kadamus, do you want to say anything before I sentence you?
No, Your Honor.
Okay. All right. Well, I've seen situations that like this, you know, as it's been described to me, charged as burglaries. I mean, you can find yourself in a lot of trouble going into a fenced area that's used to store goods. And I think I've actually seen that in the context of tow yards. So, you know, Mr. Kadamus, if you're going to be successful on probation, you've got to be careful about stuff like this. You know, whatever progress you've been making, which, you know, I'm willing to accept you've been making in treatment, you can end up just blowing that all up by stuff like this.
Yes, Your Honor.
Yeah, you don't want all your efforts to go down the drain over this, you know. Fortunately, it's getting resolved as a misdemeanor. That's good for you. All right, well, I'll accept the sentencing recommendation and impose 90 days, suspend 89 days with credit for 1 day already served. No fines or costs. The sentence is suspended for 2 years and the conditions are straightforward. Don't violate the law and don't have any contact with the Nisqually tow. As far as your probation for the violation of protection order under the 509 case number, you know, as I said, your violation is actually fairly, you know, it's a little bit more significant, I think, than maybe you're contemplating. But I think the city's recommendation for community service is reasonable. I think it's actually quite reasonable, Mr. Kadamus. So I'm going to give you a 40-hour community service sanction instead of a jail sanction. You can get those community service hours done by September 30th. So that should give you plenty of time to do it. And if it is not enough, you can ask for more if you're struggling to get it done.
Okay. Thank you.
Any questions? All right, Mr. Kadamus, you're good to go.
Yeah, thank you.
Thank you, Your Honor.
You're welcome. Okay, any others, Mr. Swinson?
No, Your Honor. I believe that Mr. Kerwin is on the surface. If I could get a breakout room with him.
Okay.
Thank you.
All right. What about Miss Kamiri? I thought I saw her a minute ago.
She may be in a breakout room. I just got an email from her on a case.
Okay.
We have an infraction pending with interpreter, and we also have the Samoan interpreter here without a defendant.
Okay. All right.
We can get somebody in the way.
Okay. So we have I don't know who our Samoan interpreter is. Tiva Aga. And
yes.
All right. Good morning.
Good morning, Your Honor.
The person that we had called you to interpret for is Vantoka Taimali.
That's correct.
And I do not see them here. So I want to be able to excuse you. And Mr. Sharp, do you have any requests for a warrant?
Yes, Your Honor. I made notes, but I don't have them in front of me. Here we go. I see one prior warrant issued on this case for failing to appear. There's one active warrant in another jurisdiction right now requesting a $2,500 warrant today.
And the notice that we sent has also been returned. So on Taimali warrant, $2,500. And our Samoan interpreter is excused. Thank you.
Thank you, Honor. Appreciate it. Have an awesome day.
You too.
Bye-bye.
She's really excited.
And then we had a contested hearing set for Tu Pham. Tu Pham. And do we have our Vietnamese interpreter? No Vietnamese interpreter? Uh-oh. She can help you? Okay, well, we'll see. Let me. I'm going to check and see if we even scheduled one. Yeah, we had Mr. Netherly scheduled. Okay, and Mr. Netherly is usually right here. Oh, well, it all may, Mr. Sharp, jump in here if I'm misreading things, but in Ms. Pham's infraction, it doesn't look like anything has been submitted in support of it.
I did email earlier this morning an affidavit, Your Honor.
Oh, okay. So there may be something here. Okay. Okay. Yeah, it looks like that was sent. All right. We need to get our interpreter, so we don't have any information about Mr. Netherly this morning. And he's not over in courtroom 1, is he?
I have no idea. I'm waiting for support.
Okay. All right. We'll wait. Okay. I'll get back to you in just a minute. Okay. So just go ahead and have a seat. All right. All right. And Ms. Kamiri, I know you've probably got some matters ready.
Yes, Your Honor. Carlos Reyes Reyna.
Okay. Mr. Reyes, good morning, sir.
I think they do get paid just for showing up.
Good morning.
Okay, and where is our Spanish interpreter? I know I saw her.
This is the foreign language trials.
She was physically here, right? I know I saw her. All right, stand by. Well, we'll find her. Was she with you in the breakout room?
No, Your Honor.
Could we address some FTAs while we're waiting?
We may as well. Why don't you go ahead and call them out?
Just going to the top of the calendar, Your Honor. Ratisami Futi.
Okay, that was for trial confirmation. Any information?
No, Your Honor.
All right. Looks like the defendant also missed pretrial back in March. All right, strike feature hearings. Mr. Sharp, you have a request for a warrant?
Given that previous FTA requesting 1,500 today.
All right. Bench warrant 1,500.
Next is on 9 o'clock, number 8, Daisy Roldan Macedonio.
That's for a compliance review.
We're just asking to reset this one. There's no warrant history. It looks like she's in partial compliance. I think the outstanding issue may be victim impact panel, but we just asked to reset the compliance.
Okay. Yeah, and it looks like she turned in a substance use evaluation yesterday, so that makes some sense. We'll reset for compliance hearing with notice.
Next, we have 10 o'clock, Renee Burnsides.
All right, that is for pre-trial. Any information?
No, Your Honor.
All right, look at the docket. There's been no contact from the defendant. Strike future hearings. Mr. Sharp.
Your Honor, she has established warrant history and one active warrant in another jurisdiction, requesting a $2,500 warrant today.
All right, forfeit posted bail and issue a warrant $2,500.
Next, 10:30, Raymond Faure.
That's F-A-U-R-E. Okay, and that was also for compliance review.
Issue is no community service hours done, so city's moving to revoke on that basis. Requesting a $2,000 warrant. I see 3 active warrants in other jurisdictions.
I see it, funky.
There's been no contact from the defendant.
Pickle flavored.
All right, issue a warrant $2,000. All right, and then Mr. Kerwin's here, isn't he? He's talking to Mr. Swenson. Okay.
And then 11 o'clock, I don't know if there's anybody else waiting besides Mr. Reyes-Reina for the Spanish interpreter. If not.
Okay. Kelvin Gonzalez Cepeda, is that you? Okay, he's here. Javier Mejia Amador. Okay. And he's here as well.
Was that pronouncing?
I think that's all we can handle now then. I do see Mr. Swinson back on the call here.
Blundering through.
Yeah, it looks like Mr. Kerwin's coming in too. Okay, Mr. Swinson, are you ready to call Mr. Kerwin's case?
Yes, Your Honor. Thank you.
Okay. All right. And Mr. Kerwin, you can, if you're more comfortable there, you can stay there, or you can come on in. Okay. Gotcha. All right. So Mr. Kerwin's here in the courtroom. He's got a pre-trial and then also a pre-FTC on a theft case. How did you want to proceed, Mr. Swinson?
Your Honor, I want to look into see how much credit Mr. Kerwin has in these cases. I noticed a recent booking. I discussed this with him and he's okay just keeping date set on the 14th. We're hoping to resolve, but I just have some things I need to look into.
Okay. So Mr. Kerwin, your next court date is May 14th at 8:30. Okay, that's already been set for you and notice sent out. So hopefully you're getting your notices.
Yeah, I like the way it is.
With the, okay, good. You getting texts?
Yeah.
Great. Okay, stay in touch with Mr. Swinson and we'll see you here in just a couple of weeks.
All right.
All right. Thanks for coming in.
Thank you.
Then I think my only other matters, we don't have a Spanish interpreter yet. Is that?
Yeah, we had her and we lost her and I don't know where she is. But she could be going back and forth between here and courtroom 1. I don't know. But it looks like we did get Mr. Netherly in and we have an infraction hearing for him. So Mr. Netherly, are you ready?
Yes, Your Honor. Yes.
Excellent. And Miss Pham? Miss Pham, can you come up to the table?
I was in this courtroom 1 to begin with. Yeah, this mixed up. Yeah, so I was there all the time. Yeah. Okay.
All right. Well, this is 2 Pham, and she's here today for a contested hearing for a ticket for improper lane use.
Đây là cái vụ của Phạm Thu nha, tại vì chuyển làn xe không đúng cách đó nha.
This is a lot of foreign language.
Pham, I wanted to let you know that you do qualify to defer this ticket and get it dismissed if you would like to do that.
Giờ Thu ha, giờ tôi muốn cho Thu biết á, là nếu mà có cơ hội để xóa cái hồ sơ này đó, xóa cái giấy phạt này đó, để ông giải thích đó, mình phải để giải thích cho nếu muốn nha.
The way a deferral works is if you don't get any tickets for the next 6 months, and if you pay court costs of $150, the ticket gets dismissed.
Thì để xóa cái giấy phạt này đó, mình phải trải qua thời gian thử thách đó là 6 tháng nha. Mà trong thời gian thử thách 6 tháng này đó, kể từ bữa nay đó mà không có bị phạt lưu thông nào đó thì nó sẽ bỏ cái vụ này luôn, xóa hồ sơ luôn nha. Với là trả tiền phí là 150 đó nha.
If you would like to do that, you can, or we can go ahead with your hearing.
Không, giờ nghe kỹ nè, muốn trải qua thời gian thử thách 6 tháng để xóa, để bỏ cái giấy phạt này, hay là muốn tranh cãi lại, tranh chấp?
Yes, yes, Honor. I am so sorry at that time. I'm so, long time I didn't know I write to land because I'm so sad and so distressed because my husband passed away on January and the New Year is very, very close and I only have $24, $39 in my checking account. So I'm so, so I didn't know I write to land at that time. And when I asked the officer, would you please forgive my fault? I didn't mean to do that. I'm so sorry. I'm so sorry. and then I don't have a peace. And so I just try going to the Saint Martin Army Church to attend the mass to have a peace. But I get the ticket, and right now every time I go around there, I feel so sad because I have a ticket. A long time ago, I didn't have a ticket. And this is my Philomena. She stay with me, and then she studied at Saint Martin University at the 3rd year. And she said that you can go to church. Honor, he is so nice, and so you can come ask him to have mercy on my fault. I'm so sorry. I did that. I didn't mean to do that. And then I usually I'm very careful, but at that time I'm so distressed, and so I would like to mercy help me to doesn't have a ticket because a long time, and when I have a ticket and the insurance going so up, I don't have money to pay. So I would like to ask you to have mercy to help me.
Well, I can reduce the ticket. I can reduce the fine on the ticket. Right now it's $145. That's the standard amount. But what you're telling me sounds like you just want me to reduce that fine. Is that right?
Yes.
Bây giờ chỉ muốn giảm tiền phạt không? Sao?
Right?
Yeah, and I want to like 6 months to if I don't have any
the deferral.
She's more interested in the deferral. Yeah. Okay. Well, we'll let you get set up on the deferral then, and then after 6 months, that ticket will be dismissed.
Bây giờ đó mình sẽ ghi để xóa hồ sơ trong 6 tháng nha, thử thách đó, 6 tháng nhưng mà phải đóng cái phí 150 đó nha.
Yes.
All right, so let's just.
Chứ không có xóa được bây giờ.
So, Ms.
Would you please can
it be dismissed right now without waiting for 6 months?
Tôi nói là nếu mà có thể xóa cái hồ sơ bây giờ được không, và tôi xin có đóng 150 đồng để.
Well, I'm willing to pay the 150, but can it be dismissed today?
No, it still has to go 6 months.
Ai cũng vậy, chị phải trải qua 6 tháng thử thách mới được, chứ đâu người nào cũng vậy đó nha.
Yeah, okay, thank
so
you, Honor, sir. Thank
go
you.
right out to the front counter, right outside the courtroom doors, and they'll get you set up on payments.
Đi ra cái quầy phía trước họ giúp đỡ mình nếu trả góp, nếu cần giúp đỡ đăng ký trả góp nha.
Thank you, Ms. Pham.
Thank you very much for your help. Bless you. Yeah.
She's like, I can pay
thank
the
you,
150.
Mr. Netherly.
Yes, you're welcome.
You.
I can pay the 150, but
you're welcome.
I want to dismiss today.
And then Mr. Swenson, Ms. Kamiri, whoever's ready. Yes. All right. Did you want to?
Mr. Reyes, Reina, we're just keeping the date set. So I don't know if you want to proceed for that without the interpreter present.
All right. She's here. All right. Mr. Reyes, can you turn on your camera and microphone?
Señor Reyes, por favor, puede prender su cámara y su micrófono.
Yes, All right. And Mr. Reyes, your next court date is May 21st at 11 o'clock.
Su próxima fecha de audiencia es el 21 de mayo a las 11 de la mañana.
All right. Sounds good, Your Honor.
Oh.
Okay. See you here then.
Nos vemos entonces.
The attorney.
Okay, Your Honor. Thank you.
The translators
You're
get
good to go.
a minimum payment.
All right, have a good day.
For each appearance. And this guy, let me just say, this guy probably didn't
need it. Anybody else?
No, Your Honor.
Mr. Swenson?
He speaks great English.
I think I'm just waiting on the Spanish interpreter.
Yo, Judge, what's up?
For those
what's
two
up, man?
in person.
Just chilling here on Zoom.
Okay.
Thanks for the
If I
interpreter.
could have the surface or have them taken into the room with the surface then.
Okay. Yeah, I'll let you work that out. Just let me know when you're ready.
Thank you.
The interpreter apologized. There were some misunderstandings this morning on cases.
No worries. No worries.
Sorry.
No worries. We didn't need you after
Please rise
all.
for his recess. Okay.
Oh, man. Good times,
So
good times. Oops.
you know how to use it. It's all right.
Let's turn that off. All right, our tax dollars at work. Yeah, there's, I don't know. I think Thomas could probably tell us a little bit, but when you call an interpreter and you schedule one, the setup, all the paperwork, all the timing, the arrangement, there's a set fee, and they show up. Even if the client doesn't, there's a fee that has to be paid. It's somebody's time, it's the connection, it's the effort, it's the training. And when you show up and you like, I actually don't need an interpreter, there is still a fee to be paid. So I'm not sure if people are just checking the box saying, yes, I need an interpreter just to make the city pay more to fight them. But crazy. I'm going to sneeze. Hang on. I've got a tickle in my nose, so I'm going to... Never mind. I decided not to sneeze. Thomas says, yes, indeed. We bill 1 hour minimum at the least pending the appointment type. There it is. So the last lady who translated for the guy who spoke Spanish but also spoke very good English is, I like this Evie. Yeah, minimum fee, hour booking. There's money, tax dollars down the drain, I guess. Not down the drain. If it's Thomas's company, of course. Those are money. That's money well spent. I only knew one person that was called on jury duty, my neighbor. We have a handful of people right now who have jury summons, just amongst chat. One is federal, so that would be an interesting jury to sit on. And then a lot of people get letters. I get texts almost all the time. They'll take a picture of their jury summons, like, "Hey, guess what came in the mail today?" I've never got one. I don't think they would ever let me serve now, but. I've never had one. I don't know why. I've got family members who are not U.S. citizens, and they get jury summons, and I don't. There you go, Bella. My soon-to-be ex texted me. My soon-to-be. Would this be? I think they refer to them as husbands. My soon-to-be ex texted me today. I have a jury summons. Been on call for Fed jury since March. Ends in June, says Sarah. Arthur Massai. Oh, that name doesn't ring a bell. Who was... What trial is this? Massachusetts. Let's see what we have. Does he have a retrial? I thought this was that's an old case, right? Natalie, what's up with that case? Did he win an appeal or something? Can't wait for a jury summons. Jody, some people have all the luck. I just have not. Had a friend that just served on a jury trial. I think it was something serious. It was a pretty serious crime. So it was there were injuries involved. I know that. I don't think it was a fatality, but an assault or aggravated assault or something like that. He served on the trial. It was 1 day, and he's like, wow, I just, now I know why you're so interested in this stuff. It was incredible. Just finished jury service in Belfast, says Shadow. Austin girl, you and me, we registered just fine, and never been called. Viola says, my husband is a blind person. He actually got to serve on a murder trial. That's cool. I love that. Watching and going downtown are two different things. Natalie sent me an email. Okay, I'll look on that. Let's see. It's thinking, but it's not here yet. Or you might have got the email address wrong. Either one. Do you have to speak English to be on an American jury? I imagine so. Or, I don't know, unless they agree to have a translator for you. But that seems like it would be quite burdensome on the court. No, says Crystal, you don't have to. How'd you like to be on the jury for the Young Thug trial, which is supposed to end when? In 5 years? 7 years? I forget. How do you take a year out of your life for a trial and then get paid $8 a day? I wonder if they ask you what I do in my spare time and say I spend around 9 hours a day watching U.S. trials. That'll get me yeeted. Master Ayden, I cannot explain the Karen Reed trial. All I can tell you is that the state is alleging that she killed her boyfriend, Officer O'Keefe, and the defense is saying that it's a setup and she was framed, and there was actually people connected to the police department that might be to blame. Can someone explain? No, Ivan. You yeet something. Say you have some food that's expired. You yeet it. You yeet it. You don't eat it. You yeet it. Bella, I would tell you this: if you're on a jury duty, if you're responding to a jury summons and they ask you questions, you have to tell them the truth. So that if they say, "Does anyone here?" and they ask a question that applies to you, you have to answer that. You have to answer truthfully. But I would not volunteer if you want to serve on the jury. I learned this from Matthew Harris, by the way. I would not volunteer any information beyond what they ask you to volunteer. The more you talk, the higher your chances of not being on the jury. So if you want to be on the jury, keep that in mind. Just because you talk, though, does not necessarily mean you won't be on the jury. You might say something that makes somebody really want you on the jury. Just know that. So it's. I watch Matthew Harris's video about how to serve on a jury, how to get out of jury service. Never volunteer. Okay, court is awfully quiet. Let's take a peek at right here. Coming up on an hour and a half of deliberation time. I think your email might have gone to my junk box. Is that possible, Natalie? I've got some other emails that shouldn't have been here. People offering to do things for the channel for money. It's in there. Natalie, I'm not seeing it. It's just not there yet. With watching this channel, my luck, I'd get picked and stand up and say, objection! What's the latest with the Treehouse case? I think there's a hearing scheduled. Let's see, Franklin Tucker is 6/17. Is the new date. 6/17. There's a hearing that they just had on April 4th that set that date. Oh man, those are so good. I love them. I need to get some more. I've used up all my the green pepper flakes, which I personally think is it's not so hot that it makes dishes like fire, but you can add them to all sorts of things. You add them to mashed potatoes. You add them to omelets. You can put it on chicken that you're grilling. It's so good, so good. One of a few birthday presents from my son. Good stuff. Good stuff. I hope you enjoy them. Ivan says, if RA didn't exist, I'd be forced to go back to my old hobby of calling into obscure AM radio stations and causing drama on air. Ivan, it's funny that you do that. I also had that hobby. As a matter of fact, it was sort of a funny story, I think. I found a radio station, a talk show radio station that I'd call into and talk on. And somehow my sister started dating the talk show host. Yeah, I don't know how that happened. But I don't think it lasted very long. But it made Collins a little different, especially after the breakup. It's like suddenly, he doesn't want to talk to me on the air because, I know too much or something. No, we didn't, but we did at one time go to the radio station. Like, we were both there at the same time. Why does the clock only show 41 minutes now? B. Padilla, you probably rewound, so you might not hear this anyway. I'm at almost an hour and a half. Ellaby, I'm still confused. I think yeah. In case you outed him on the air. That's probably why. I probably shouldn't talk about it, but it's not my story to tell. That's all. That's all I can say. Hang on, Ivan. You had a name to call in under? Hey, this is Jed. This is Jed. Jed used to have a live 2-hour talk show on the radio and he'd take calls from people in jail. It was a hoot. Let's add rewatch crew. That's a good idea. I have not added anything about replay or rewatch. There were polls. The polls are done. Deliberations, we think the jury will deliberate, and I think most people think he's guilty. Both of them are guilty. I'm still gun shy from last time, Samantha. I haven't decided if I'm opening up the burner phone or not. There's not a lot, I'll tell you, there's not a lot happening in courts today. I mean, it's been a busy day, but now there's not a lot happening. It's very, very quiet. Let's see. So yesterday, Ian Runkle did a story about a court proceeding that was disrupted by an indecent Zoom bombing. And I don't know if he's going all the way back to the early days of Young Thug, but that happened to us. I'm not sure which one he was talking about. I missed this yesterday. I'll have to watch that. It's quiet. It's really quiet. Natalie, let me check and see if it came through this time. Sorry, I just read something that was very funny. There, Natalie, I got it. Hang on, I need to program a key code. Starts April 29th. Hang on. Okay. I can look into it, but typically we need a lot more lead time, Natalie, to get access to a case. Let's see. All right. Deliberation clock is going slowly. It's only been an hour and a half. They have up to 3 hours left to deliberate. Burner phone's definitely in there. Burner phone's going to be in there for sure. I don't want to tell you my lyrics because I don't want somebody to use them in another rap because they're that good. They're subtle jabs, but at the same time, it's all friendly. There's nothing like mean-spirited among it. Yeah, but I've got probably enough for 3 rap songs in here. The lyrics, I just have to shape the story a little bit, and I don't know where to start. It's basically the rap song is basically the premise is the RA channel's been taken to court. That's the basic idea of that, with the prosecution being other channels. Okay, that's the storyline. Burner phone's still here. I think it's off right now. Is the burner phone off? Let me check. Settings. Oh, it's actually on. We just haven't had any calls. I'm not leaving yet, but I actually need to do some business with the Airbnb for the renters that are coming. So we need to either get Mrs. R.A. in here. Actually, let me call her real quick. I think they have me on ignore. I don't know where the accused is, but he can't be back at jail. He has the right every time there's a question to be brought up, but I guess that's the same right that Mr. Richardson should have.
Call from
Master Eden.
Hey, Master Eden, this is Scott. How are you doing?
Hey, man, real quick, I'm at work. I can give you an idea. If you had to be charged for anything in the world, I would say kidnapping. Only because you've always stated that once you're here and you have joined the channel, you can never leave. And if other channels have to charge you with a fine, that could be the charge.
That's the charge, kidnapping. I was thinking false imprisonment might count, but yeah, that works.
I mean, yeah, your word. So we're gonna give you a charge. Let's go that way.
Yeah, well, I was in the spirit of the rap song that we're writing. The charges are basically they're dissing me. They're disrespecting the channel. That's the charge. And so I'm sort of working that in. And I've got I can't wait. I'm so excited. I literally like smile every time I read the line. I'm like, oh, that is so good. That is like gold, and I can't wait to share it.
I seriously hope you have some ad libs of the sound bites you have with the judges. And,
we are putting some sound bites in there. So
good.
It's gonna be.
Because I used to do music, so I really hope you get some of those. You go so perfect with the rap song.
Yeah.
Okay. Well, I just want to throw it in there real quick. And, I'm with you, both guilty. I was kind of trolling. I was like, justice for Max, and I was just trolling.
Okay.
With the Bible on it and everything.
Yeah. Nice.
All right. I'll let you get back.
Thanks.
To you.
Appreciate it, Master Eden.
Right,
We'll see you.
You too.
Bye. Ashley, I'm glad you got the I stepped on a bee part of the rap. That's obviously referencing the Johnny Depp trial where Amber Heard, my dog stepped on a bee. Is this the jury for Karen Reed? Doing my best, boss. It's not. That case is actually just in the beginning days. I think it's on day 2 right now. Out of 7, 8, 9, 10 weeks. I don't know how. It's going to be a long case. It's going to be a month or 2 before that goes to the jury. It's going to be a long one. So this case that they're deliberating right now is it's actually a YSL gang out of Georgia. It's a gang trial, but it's an Airbnb armed robbery that occurred. 2 defendants, 2 co-defendants, but one defendant is pro se, meaning he's representing himself, and the other defendant has lawyers. And so we've watched this trial over the last 4 or 5 days, and it's in deliberation right now. 20 charges, well, 19 now. Judge dismissed 1, but there were 20 charges initially. Karen Reed's supposed to last 6 to 8 weeks. I think it's going to go long. Didn't get the B part. I didn't see Def Fjord Holanova. That's one of the good lines of the other rap we had. Because I put it in there to say that basically when other channels try to be as great as we are, because that's what rap is all about, right? You're trying to say how much better you are than everybody else, even if it's not true. And in this case, it's not true. But in the rap, we say when other channels try to be as great as we are and they fail, then they're like, oh, I stepped on a bee. And it's basically just making excuses for why they don't succeed. That's what it was for. Let's go. RA is back up for other channels. I want to do two raps. One rap is just LawTube in general, just the greatness of LawTube in all its variety. Okay, because honestly, the not just the pillars of LawTube, but the outliers as well. Just some great, very interesting, diverse, smart, witty, fun, edgy takes on trial. And anything you want as far as trials go, you can find it. Whether if you just want the funny and you want to, see the crazy, you can go, Law Talk with Mike. You can go, Squishy Gardner. There's all these different channels where you can find just what you're looking for in the world of courts. There are some that get heavy into the details, and a lot of them are official LawTube channels, like if there is such an official thing. But actual lawyers, practicing lawyers that are getting deep into the weeds on motions and things like that. You should add Kathy from Gossip into your app. There are so many people. If I start adding people, I'm going to leave people out. I know it. Shorts are classic now. Yeah, I think on the LawTube rap, I'm going to stick for the most part with the big names. So there'll be references to Ian, to Peter Tragos, to Rob from Law and Lumber. Might include Hogue Law, Emily Baker. You'll have references to all those. Rakita's between serious and funny. Sometimes he's really, really edgy too. Like so far on the edge, it's like, whoa, I'm not sure if it's legal for me to watch this, let alone, for it to go up. But I'm not starting beefs. It's all in good fun. And I have the utmost respect for all the other creators in this genre. You didn't like the remix as much, Fun and Funky? You like the original one? The original was by Courtney. Meek sent the first one, and I did a change to that one. There were some things I wanted tweaked. This is what singing Happy Birthday every day has been preparing me for. Abby, if I can take some time off, I might be able to have the rap ready today. There's a possibility there. We need a judge's rap, please. Shout out your boys. Emily, don't forget your uncle. Ian's in there. Like Broken Baker, they've been very very good to us, portaling over quite a bit. We appreciate them, and we've tried to return the favor when we can as well. I could rap with my voice. It would actually be easier to put it together that way because I'm struggling to get everything I want into the rap the way I want it to fit. Do it now. I'm so anxious to hear it. Fun and Funky, did I see your anniversary chat? Let me take a look. Might have popped up when I was not looking. There it is. My goodness, I joined when Letitia was on trial to get a word in edgewise in chat. I still love it in here. I just wish you'd get a Wi-Fi phone. Fun and Funky, I'm sorry. We're trying to figure that out. We tried one method, but it gave away my personal home number, like my permanent cell phone number. And as cool as that might be to other people, it's not very cool for me. I need to be able to isolate and turn it off, or if needed, switch it and throw away the burner phone and get a new one. Master Ayden, thank you very much. 4 months. By the way, Fun and Funky, 13 months. Thank you very much. Master Ayden, 4 months says Rap Battle RA versus Ayden. Thank you, by the way, Master Ayden, for gifting membership. Let's see, we had a super chat from Ivan. Thank you very much. New legal venture. Can't wait to hear about that. Maybe off air. Cindy Collins, been watching Karen Reed today, but tuning in now to catch up with y'all. 5 months, Cindy. Thank you. Mandy Strong, upgraded to gallery. Get the padded seats, Mandy. That is awesome. Special K, welcome. Hope you're still with us here. Brand new member today. Thank you. Rocky Wallingford, welcome to the gallery. Art Grigo, if innocent, 4 years is a long time. Good point on his part. This was way back in the closing statements that we heard. This one came in. Let's see. Kayla Newell says, so far I heard the guy even looks like me. Those aren't even the colors of my YSL gang. They stole shoes. Something about Constitution. I'm convinced this might be my neighbor. Let's see. We had 7 for 16 months. Demand RA7. Thank you so much. Also, Cheryl Bybee, love this chat. Hey, y'all. This community is the best. Thank you, Cashette, for the 15 months of support. And also, Kathy came in with a super chat saying he's doing better than his comrade's defense attorney did, in my opinion. Kathy, also another super chat there. Thank you. Thank you for both those. Sorry I missed it when it came through originally. You should do a music video of your rap song, and we could send in pics of ourselves, and you can superimpose them. I hear that this idea, but in my head, I'm seeing 56,000 emails of pictures, which I can't authenticate as my own, and I'm pretty sure somebody's going to send in like a picture of Pamela Anderson instead of them, or and I'll be putting up other people's pictures, and then we have copyright issues. I hear you, but I'm not sure if I can do that. Golden Girl, who owned the internet this morning, can't believe I've been in a gang for 15 months and didn't know it. Golden Girl, welcome. Great job with the internet this morning. Let's see. Been watching KR. Did the accused do a closing statement? Jamie, he did a closing statement, and it was different than anything you've ever seen before. I mean, it was the same to some other things, like he had the Bible in there. But it was very different. You've got to go back and watch. I don't know even how to describe it. Lots of happy anniversaries on the channel. Thank you, Nova. Let's see. Megan Fox will give you a run. She's into Suno like it's Legos. Hey, let's do it. Let's do it. I'll battle Megan Fox with the rap. I still have to get Megan some gear. We're going to do that. We're going to get them some gear for a trial that's coming up. This trial didn't worry you about Airbnb? It does. As a matter of fact, I just got an email or a text message about Airbnb, and we have to hook some things up. But awesome. Thank you, Big Mike. Just got the text. Thank you. That's really cool. Hope the next rap is your voice. Okay, so if I do my voice, I just need to have the beat mixed together. And I've been playing with an AI music maker called Fader that should be able to put the beat together. But I want to have some variety and some change up, and it's not very good at doing that. I have left Dr. Joe out intentionally. I'm not sure if he wants to be dragged into a rap battle. You want me to wear a dress for the music video? No, just kidding, Peter. What I wear will become like the gang colors then. Whatever I'm wearing when I sing the music, when I'm in the music video. They're still deliberating. The box in the top right-hand corner is live, a live view of the court. So when you start seeing activity there in the top right-hand corner, that's when we can expect some motion or maybe some action in court. You want my voice rapping? I'm not very good at it, but I'll try. Wear the kilt. The problem is my kilt is about 2,000 miles away and about 4 inches too small. Yeah, Dr. Joe would think it's fun. It's fun. Purple green. I like blues too. Lots of light blues. I've got so many light blue shirts. It's not funny. Mountain Dew gang. Even better. You guys are the worst. Oh, that's funny. The kitty's back. The kitty's back. Came back today. He was gone for a few days. Came back just to get pet. Looking at, is there a motion in the court? Oh, I thought somebody was sitting at the defense table, but they're not there. All right, let's take a break. Do you guys want to take a break? I can keep this going, and we'll go live as soon as something happens. But that would allow me to practice my raps, because I have to do it out loud, and it helps to be able to hear. Break for an hour. Let's do a break for an hour. You guys have a few things you can do. We'll be back. There's not a lot of other things going on, unfortunately. There's not much I can send you to, or I would. Let's see. Let me do a quick check, see who's up and running. Legal mindset. International tax troubles. Some storm chasers alive. Kurt's live on civil law. We haven't rated Kurt in a while. He's talking about New York Times doesn't understand the law. That might be interesting. Give you something to listen to while we're waiting for the jury to deliberate. It's been almost 2 hours of deliberation time with this case. So we'll break for about an hour, and I'll keep the audio on. If something happens, we're going to come back and bring it to you. Peter's on there. Peter's on there. That's Kiki. I don't know. I think we chose Kiki because it was like kitty, kitty, here, Kiki, like that. Blue fishing shirts for everyone. That's going to be our gang sign. Oh, wait. Somebody just walked across the screen. Right as soon as I said we're going to take a break, bailiff walks across the screen. I could get out the hairbrush and practice in front of the mirror, but I can also just sing into the mic and mix it up on the ones and twos like I do. Okay, we're going to give it just a minute to see if something's happened here. Need a bathroom stream still. It sounds bad the way you ask for that, but I know what you're saying. I don't have any good pictures. Who's creating the rag wiki? I don't know, but it's probably going to have some errors in it. Evie. Trust me, that won't happen. Can I full screen the courtroom during the break? Let me think how I can do this. If I run a second stream from a different computer, so like over here. Say I put verdict watch over on top mark, and so I'll leave the verdict watch going, just like you're seeing right here. It's a little tricky because it's actually the audio that's the problem, because I need the audio system to be able to do the raps and the music, and that would be going over the live stream at the same time. You guys want the panel? Let's do this. Let's take a break. If nothing happens in 1 hour, okay? Well, let's see. It's 4:30. It looks like we're watching the jury deliberate, right? I'm trying to think this through. If nothing happens in an hour, it's going to be 5:30. They can deliberate as late as 7 o'clock tonight. I don't think they'll go that late. I think they'll probably go home their regular time. Let's do this. Let's take an hour break. I'll be watching. If anything happens, we'll come back. We'll give an update, and we'll see. Possibly do. Possibly we'll do something with opening up the phone lines or the panel afterwards. But I'm not sure I want to do that yet. So, I think the bottom picture is an actual jury. It's just not this jury. This judge has no problem with showing the jury. He's cool with that. So, all right, give me a break for a little bit. Let me work on my song. Hopefully we'll have something put together. Yeah, the panel is a lot for me. I get so nervous. So, anyway, we'll do a break. I'll work on the song, get a couple things done with the Airbnb as far as logistics for the person that's going to be coming in, because I have to set up some access codes and have to program the digital locks to allow them to come in during certain times using a certain code and then stop working after a certain time. So, can we hear? Whoa! Can we hear the current song on the outro? We could. Let's see. Let me back it up here. Where's 3? To turn off this. That down. Sorry, I've made adjustments to the audio for court, and I have to go back to just the regular audio for this. So, all right, so we'll do this as the outro for.
Wake up in the morning wearing headphones. I'm running court into your brain like it's an end zone. My money's green like the pickles and you want some. Don't interrupt cause I don't want your lame objection. From land t-shirts to murder, I think I've seen it all. From picking juries to when the gavel falls. The judge takes the bench and the bailiff yells all rise. And pay respect to the one and only go to true crime. Imitators they try but they just can't achieve. And when they fail they be like, ow, I stepped on a beat. Take the stand and the jury chooses not to believe. Because there will never be another creator like me. Big deal in one corner and the count in another. We've got the judge reading chat while we talk to the lawyers. All our clips go viral, they're the good not to share. Came in late, check the thumbnails, you'll find it all there.
I'm not a camel.
They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal. They say I'm addicted to rhyme, but it's more than just time. And the mic is hot, the gavel drops and I'll be talking about crime. And don't you worry about the sound, cause I'm keeping it real. Just like a pickle jar, but I'm one big deal.
Scratch all that. Oh, that was terrible. I apologize.
Is that correct?
All right. Court is now in session.
There we go. There we go. You guys are having fun in chat. Yeah, we're going to work on the new version, which is coming. My ears are ringing now. I had the volume cranked up in my ears. But we're working on the new version, round 2, the start of the epic rap battles of LawTube, I think is what, I don't know what else to call it. I was falling asleep and suddenly this happens. All right, you guys, tonight when you go home, please talk to the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again in about an hour when we anticipate the jury. Maybe the jury has at least a question or something for us. So, punk rock version. Man. Megan's version. Which one's Megan's version? Courtney's? The original one? Where it says liars instead of lawyers? All right. You guys be good to each other. We'll be back in a little bit. Give me about an hour. Thanks a lot.